Acquisition matter, my lord. The state is constructing a bridge without on my land, my lord, without any land acquisition procedure or any compensation. Matter is urgent, my lord.
My lord, yesterday I have mentioned, my lord, matter is serial number 209. We are the co-partners, daughters. Our property has been sold by fraudly by the beneficiary. Now the court is going to release the amount of 21 crores in his favor of the beneficiary, open number 3. All right, tomorrow, my lord.
It was some fine. Because transmission of the appeal is subordinate judiciary processor or matter can impose penalty in the departmental proceeding. He submitted the appeal before through proper channel. That is not placed before the appeal committee.
That is not?
Sent to the appeal committee of this court, mine. I to read application. Another matter, I am challenging the selection of the Justice of Qatar, copyist come clerk matter, 2019 selection. That may be any date. Item number 1.
Sir, I am there. Page 90 to the infused order introduction kindly look at it. Page 98.
What happened on 20th?
Sir?
On 20th, what happens?
Sir, I filed an application referring to your order that my application has been kept pending so far as a notice to the opposite party 4 and 5. The Honorable Court was pleased to issue notice to them.
Okay.
Saying that I kept it, I couldn't issue notice.
So when the date fixed?
So 18th is the date fixed.
18th of?
18th of October.
Yes.
Sir, I just wanted to bring your notice once more.
So once you have availed the alternative remedy,
so on merit, I am not urging your orders to pass any order because the matter is pending there.
Then,
so what I beg to submit it to your receiver. Right, just give me 2 minutes. Let me explain.
No, Mr. On that day also you said in that Bafna case, what has been said that when alternative remedy is available and the other side has already approved that,
yes.
So High Court should not entertain 226.
No, this is not a case of that type.
No, this is different. This is in any case, that is principle. Principle is same. Principle is same that when we
what I'm going to submit, not an order has been passed. Rightly or wrongly, an order has been passed by the authority. But what has done on page 90, but there's an interim order by the RDC. RDC examined the case, right? Director status could be maintained. But we had raised up to plinth level construction, and 2 pillars were there. Now the present construction is on the very same foundation. Same foundation. But the day it was.
No, how can all these things be adjudicated?
That. What I beg to submit, only one point actually.
Yeah.
But the court has said, I moved the application for implementation of the interim order.
Yeah.
The court said, I peruse the appeal memo, find there is no prima facie case. The interim order is withdrawn. Interim order was not heard on that day. I was appearing it actually. Interim order was never heard. No LCL was there. Previously, the LCL was called for. Parvai's comment was called for. Record was called for. Nothing was there before the court. The court says, peruse the appeal memo. I find no prima facie case. The interim order is
withdrawn. So whether for that purpose you are to file a separate writ petition or you can agitate this in this particular writ petition.
So I have to challenge for lots of the reason being the court.
No, challenge means in a separate writ because that is this writ petition was filed much before that order was passed.
No, this is the one. This is the writ application where that order is.
No. This interim order, as you say,
yes.
That was passed perhaps after this filing of this writ petition.
No. That interim order was passed much before that.
When you filed this writ petition?
So writ application has been filed after the order passed to page 98. That if Lordship looks at the date, this 5/9/2020.
No, after 30th.
Previous order was that writ application, your Lordship directed I appeared. Because the RDC was not there. Your Lordship is absolutely correct. I bow down to your Lordship's order. That I am not pressing. That has been disposed of already.
Yeah.
This is on 30th, the order has been passed. And I filed this on 5/9. The reason being, so there was an interim order. Nothing has been heard. I filed an application for implementation. Your Lordship directed the order has to be implemented.
So,
what is the prayer to that effect? That the order which has been passed should be set aside or modified, whatever it
If you also look at the prayer method, I have challenged that order.
is. So this.
In the writ application, I challenge only that order itself. E valedictions. D and E.
D and E, prayer.
Yes, yes, prayer.
D is of
And if you also say B, D and E. B, A, B, small b.
Oh, B for
The order dated 38/24 passed by the Revenue Commissioner Central.
Okay, who is
Five
for the other side?
Will not be set aside with pass.
Mr. Misra, who is for the other side?
State is there.
Only no other.
No other party.
What you say about this order which has been passed on? There was a status quo order, and he was supposed to hear the appeal. And what he did on that day, on 30/20/24, just come to that order. What page, Mr.
Page 98.
98.
Page just read it if you also permit me.
Please place that order. 98.
Yes. Well, it says, there is the application. Let me read from paragraph 2. There is the application of the petitioner 39/2022 where he has prayed for implementation of the status quo order 42/3/2024, stating that construction of the suit line has been initiated. Same is progressing rapidly. By order dated 42/8/24, the Honorable High Court had directed this court to expedite the matter and dispose of the same in accordance with law. Honorable High Court has also opined that status quo order passed in 22/3/2024 shall be implemented till the matter is taken up by this court. Today, applicant has filed an application stating that he is made to understand that construction has been carried out by Department of Tourism, Government of Orissa, along with the Tourism Department Corporation. Prior to add them as parties, the application kept on record. The petition contains that the impugned order of the collector Jagatsinghpur dated 16/9/23 is not speaking order, and section 3B, that's the original cancellation order. 3B is not applicable to the present case. Peruse the original appeal memo dated 16/10/23. Admittedly, land was allotted by 13/12/2006 for construction of hotel for a period of 19 years. So cause was issued by the Tahsildar, so and so. Violation of clause 2(6) and 4(2) of the lease deed are explicit nature. As per photo submitted petition, no construction except 1 or 2 pillars were made on the suit land for a period of more than 12 years. And status quo order continues. There has to be prior case in favor of the petitioner, hence the order is withdrawn because they were heard. And if your lordship looks at the terms and conditions, they have to give a notice. Then after notice, if I fail to do that, they will give 7 days notice to comply. If I don't comply, they will resume.
My lord. Initially heard on 18/9. Then on my prayer, matter was posted to 19/9. On 19/9, my lord, my lord senior, before I could say, my lord senior placed the order, which originally the case was posted to 29. Now on 29, the matter was taken up. The impleadment petition was allowed, and the petitioner was there. And the requisites were to be filed by him within 3 days, and matter has been posted to 18/10 for final hearing.
No, that is to be heard. We are not on that. Let him hear the matter. He's just aggrieved by the manner in which this status quo order was withdrawn. So it is that order was very much in his favor. And this court, while disposing of that earlier application, that is the writ petition, directed that the status quo shall be implemented. That means it's to continue till the matter is taken on. Yes. So all of a sudden, if you vacate the status order, that is without giving this order does not show that the state has any kind of objection for the continuance of the status quo order. So it should have allowed to continue or at least ये जो लाइन टा लिखी चंदी
Peruse the original appeal memo admitted in the here they wrote there.
No construction except one or two pillars was made on the suit land for a period of 12 years. ଏଇଟା ସିଏ କେତେ ଗୁଡାକ ଫଟୋଗ୍ରାଫ ଦେଇଛନ୍ତି ଯୋଉଥିରେ ଜଣା ପଡୁଛି ଯେ କନଷ୍ଟ୍ରକ୍ସନ କ୍ୟାରି ଆଉଟ୍ ହଉଛି ତାପରେ ଇଏ ଗୋଟେ କୋଉଠି କଣ ପାଇଗଲେ
Yes, he is speaking about the construction made by the petitioner, but that is not the case. So it should have been a speaking order, no? A ecliptic order has been passed.
So I will leave it to my
that much of prayer what he wants, that at least for vacating that order, withdrawing that, the reasonable opportunities would have been given, and his statement which has been made that the construction work was going on and it is supported by some photograph. At least for ascertaining the correctness of that thing, some instructions would have been sought for from the Land and State Council.
exactly.
Unilaterally that was decided and withdrawn.
So
So let a speaking order be passed.
Dispense with the power-wise comment and calling for a
So it's all right. Let the
Sir, what I beg to
reconsider it and pass the order about the.
let the status quo continue.
No, we are for reconsideration. Obviously, this order goes. So
Status quo remember.
let me this writ petition has been filed by the petitioner so and so, entirely challenging the order dated 30/8/2024 passed by the Revenue Divisional Commissioner Central Division Cuttack in OGLS Appeal number 05 of 2023. As it appears, the said appeal was filed by the petitioner challenging the
Resumption of
what is that order challenging that OGLS?
Next section.
resumption of lease order.
Please show that
was on the in the appeal.
which is the order which is included in that OGLS appeal.
Yes, sir. 16:9. Annexure 12. Annexure 12.
Sir, Annexure 14, 13/12/2023.
14.
Yes.
14?
Sorry, this one.
No. 12.
Annexure 12,
12.
16/9/2023.
Yes, sir. 12.
Challenging
Page
the
67.
the said OGLS appeal was filed challenging the order of the collector and district magistrate Jagatsinghpur dated 16/9/2023. In which
Single line.
it has been held that in pursuance to the condition laid down at serial number 3 of the office sanction order number so and so, and in exercise of the power vested under section 3B of the OGLS Act 1962, the
Authority resumed.
the authority resumed
The lease case.
the lease of the land, lease of the government land measuring 1 acre in favor of the petitioner by lease case number 01 of 2006. Stop. The
In favor of government.
appears that earlier
In favor of government.
the petitioner approached this court in WPC number 1999998 of 2024. Where is that order? Have you annexed that?
I have annexed it.
70.
70?
My lord. 69. WBC 32289 of 20.
Correct. 322 first.
No.
Page 84 annexion.
Page 84, annexure 19.
84. Amuli order.
No. Page 9. By such rules.
Which was disposed of on 22/8/2024. With a direction to the Revenue Divisional Commissioner, Central Division Cutter, to take up the application filed by the petitioner. What is that petition?
For implementation of the order.
For implementation of the status quo order dated 22/3/2024.
Restoration of
Soon after, he joined and to dispose of in accordance with law.
So that has not been disposed of.
And it was further observed that the order of status quo dated 22/3/2024 passed by the RDC shall be implemented in letter and spirit till the matter is taken up by the Revenue Divisional Commissioner, RDC. It appears from the improved order dated 38/2024 that even though the appellant filed an application that construction is being carried out by the Department of Tourism, Government of Orissa, along with the Orissa Tourism Development Corporation, and a prayer was made to add them as opposite parties number 4 and 5. The application was kept on record. However, the RDC observed that as per the photo submitted by the petitioner, no construction except 1 or 2 pillars was made on a suit land for a period of more than 12 years. And further held that for any status quo to continue, there has to be a prima facie case in favor of the petitioner. And accordingly, the order of status quo dated 22/3/2024 was withdrawn. Mr. Misral and senior advocate appearing for the petitioner submitted that the order of withdrawal of status quo was passed in a mechanical manner without hearing the parties and without ascertaining as to whether the averments made in the application by the petitioner that the construction was going on by the Department of Tourism of Government of Orissa along with Orissa Tourism Development Corporation is correct or not. The Land Council further submits that when the case was posted to
20th.
last on ODA now 2024, the aforesaid the application of the petitioner to implead so and so as opposite parties number 4 and 5 has been allowed, and notice has been directed to be issued to them, and you have filed your requisites.
Sir, please.
And requisites have already been filed, and the case is now posted to.
Yesterday only we got the order, certificate copy of the order. So we are filing the requisites today because the order was not available for us.
And the requisites is likely to be filed during course of the day for issuance of notice to the issuance opposite party number 4 and 5. And the case is posted to 18/10/2024 for appearance of the opposite parties number 4 and 5. कौन order चाहिए थी पढ़ ले?
Wanted to sit up.
18/10.
Petition is directed to submit consolidated cost title and postal requisites within 3 days and issue notice on submission. List the case on 18/10.
And the case is now posted to 18/10/2024. Since the order of withdrawal of the status quo appears to be a cryptic in nature, and it seems that the RDC has not heard both the parties and not tried to ascertain whether the averments taken in the application of the petitioner relating to the construction work being carried out by the so and so, whether it is correct or not, we set aside the order of withdrawal of status quo and direct the RDC to hear the matter afresh relating to the continuance of the status quo order till the disposal of the OGLS appeal number 5 of 2023. After appearance of the opposite parties number 4 and 5 on 18/10/2024, if the matter is not taken up on merits, the OGLS appeal is not taken up on merit on that day, the continuance of the status quo order till the disposal of the appeal will be taken up on that day. And after hearing all the parties, order is to be passed. In that respect, it is made clear that we have not expressed any opinion on the continuance of the status quo order. Accordingly, the petition is disposed of. Copy of the order being handed over to the Land Council for the state for onward transmission to the RDC Central Division.
So one observation required, because I have challenged the virus of the statute.
Yes.
Let me observe that for the timing that's not present, we to raise it.
Mr. Mishra and Council submits that no other prayer has been made in this petition, but for the timing, you are not pressing those.
That is liberty to raise it.
He may be given liberty to raise those points awaiting the results of the after the OGLS appeal so is disposed of finally.
One thing I would like to show, one document contains the order of the court.
The order dated 29/2024 has been filed, which is kept on level.
Wait, listen to the last sentence of that order, subsequent order. Sanitarians order. RDC order. So before the last sentence of the order.
Yeah. Petition was already
dispensed with the Parawai's comment and the LCR.
Yeah.
I don't know why he has dispensed it. It was called for. It was not available in the record. He said available. Now he has said dispensed.
As the parties have been given full opportunity to adduce documentary evidence. So also the oral and to address the court to advance oral submission for adjudication of OGLS appeal number so and so.
first line is in favor of the government, sir, in favor of petition.
Resumption beliefs granted in favor of the petition has been resumed in favor of the government.
Correct. Yes.
Number 2.
Yes, Mr. Pali, what are you challenging here?
I am challenging my lords.
Annexure 10.
May I have my lords? I have filed an intervention petition.
Object to matter. I would
He has
object
filed
to
an
that.
objection.
Lordship, you are asked
All
first.
right.
Can be first.
We hear you. There is no problem. Please begin.
That I have several allegations are made against me. That's why I'm before your lordship. Unless I made a party and allegations are there.
Proceeding matters, it's my continuance.
That's not the only thing. He's making accusation against me. Even my documents have
So file a defamation.
are annexed.
Who are you? Who are you?
I am a co-professor, my lord.
No.
I'm Manoj
Dr.
Kumar.
Marti.
Manoj Kumar.
Intervention has not
That issue between you two.
No.
He says at my instance this proceeding has been initiated.
No.
And there are, yes, that is what he has been saying. And that certain documents have been annexed, which belongs to me, which he has obtained through RTI. If your lordship
That is not
5-10 minutes, I'll show the announcement.
No, we see that if anything is against you, then definitely you will be.
Just a moment, please. I can't have a say unless your lordship recognizes me in the case.
No. Once we find that anything is against so and so, which is taken as a
So
ground
there
to
is prayer against me.
no. So there is no prayer. So yes,
He may say so that no, these allegations
Yes.
made are
please argue. Yes.
at the moment I may not have any say, your lordship. That's the problem.
No, see that. Let us see hear it. Yes, item.
Senior my lord, I beg to submit.
Yes. We are not hearing on those issues.
No,
We will hear both of you and mention the. Yes, please proceed.
no, there is an interim order.
Yes,
to
please.
invalid continue.
We have to address the. Yes.
grateful. The long and short of the matter is this, Manners.
Yeah.
A fact-finding committee was constituted to inquire into the complaints raised by me against
What you are
others.
challenging here.
Manners. The institute, the show cause itself,
Let us come to your prayer.
Manners. Prayer page 20 is therefore humbly and most respectfully prayed that this honorable court may graciously issue a writ of certiorari and such other appropriate writs, thereby quashing and setting aside the order dated 12/3/2021 passed by the learned Central Administrative Tribunal at Annexure 10 of the said petition, and further be pleased to quash and set aside the show cause notice under Annexure 9 issued by the opposite party.
Was passed by the Central Administrative Tribunal, Annexure 10, please come to that.
10.
Yes.
And then, Manners, further be pleased to quash and set aside the show cause notice under Annexure 9 issued by the opposite party number 2 declaring the same as illegal.
Come to Annexure
That
10
will
pass.
see.
Will Annexure 10 pass.
Manners. Annexure 10, your lordship finds at page
So the same show cause notice was challenged.
Man, in the same
Yes,
show cause notice I also
That
found.
was perhaps turned down.
Yes,
Okay.
that was turned.
Okay.
That's at page 83, your lordship finds at page 8. The appellant has filed his original application praying for the following reliefs. To set aside the impugned show cause notice under Annexure K9 issued by respondent number 2 declaring the same as illegal, arbitrary and without jurisdiction, bad in the eye of law. B. To set aside the impugned fact-finding committee report under Annexure A9 issued by the respondent number 2 declaring the same as illegal, arbitrary and in violation of the CCS rules 1965 and bad in the eye of law. And C. To direct the respondent number 2 to drop proceedings against the petitioner appellee and reinstate him as HOD of the department in pediatric surgery who is the senior most faculty in the said department and any other orders. The appellant has inter alia challenged the show cause notice under Annexure A9 on the ground that the director aims has set aside the show cause, issued the show cause notice based on preliminary fact-finding committee recommending certain harsh steps
to be taken against him, including removal and dismissal, etc. It is submitted by the learned counsel for the appellant that the director aims has no competency to issue such show-cause notice. As such, as there is no mention of the same was issued with approval of the appointing authority, that is the Board of Directors of AIMS. It is submitted by the learned counsel for the appellant that Dr. B. Jindal, who was one of the members of the preliminary fact-finding committee, is about 12 to 14 years junior to the appellant, and that certain documents sought for by the appellant vide annexed application dated 10/8/2021 under Annexure A12 have not been supplied to him. However, it is submitted that the learned counsel for the applicant submitted by the learned counsel to the applicant that the applicant, without prejudice to his right, has submitted a reply to the show cause. In support of the case, learned counsel for the appellant has relied on the decision of the Honorable Apex Court in the case of Oryx Fisheries Limited versus Union of India and others, reported in 2010, SCC, mentioned in the OA, paragraph 5.10 of the OA. On the other hand, Mr. Verma, learned senior standing counsel appearing for the respondent, has drawn attention of the tribunal to the show cause notice, page 77 of the OA, and has refuted the stand of the learned counsel for the appellant and the show cause issued by the director aims is without approval of the competent authority. We have considered the rival submissions of the respective parties. The fact that Dr. Jindal is one of the members of the preliminary committee was junior to the applicant is of not much importance at this stage, because Dr. Jindal is not working in the place where the applicant is posted. Therefore, his inclusion in the committee cannot vitiate the fact-finding preliminary report of the committee. It is further submitted that Dr. B.B. Tripathi is biased against the applicant and therefore should not have been included as a member in the committee in question. The allegation is not based on record. Mere conjectures and surmises is of no importance. We do not know whether the applicant would be able to prove the same before the competent authority. Mere recommendation or observation of the preliminary fact-finding committee cannot be a ground to come to the conclusion that the entire proceeding will be vitiated and there is no sufficient ground for interference by the tribunal at this stage, because no prima facie ground is found that justice will not be done to the applicant and he will not be given a fair opportunity of hearing by the authority concerned. Rather, we find sufficient force in the contention of the learned counsel of the respondents that on consideration of the reply, it may so happen that the authority may choose not to further proceed in the matter. Accordingly, we are not inclined to interfere in the matter at this stage. However, it is expected that the respondents, after considering the relevance and necessity of the documents sought for by the applicant under Annexure 12, may supply the documents to the applicant as per rules of law with the aforesaid observation of direct deduction, the way stands disposed of, no cost. Against this order, my lords, I approached your lordship.
Okay, just 1 minute. One order was passed by this court on 5/11/2021.
5/11.
It was held in paragraph number 6 that as an interim measure, it is directed that the proceeding initiated by the opposite party number 2
may continue
on the basis of Annexure 9 may
until
proceed.
final order.
Final order. So, what is the stage of the?
And now proceeding is continuing, my lord, but no final decision has been taken.
Some witnesses are still to be examined.
Okay, one thing we just want to know that when this court has granted you that Central Administrative Tribunal that these documents are to be supplied to you. So you have already filed reply by that time. So did they supply any documents?
They did not supply. They did not supply me the documents.
Because that order which you just now read, please come once again to that order.
That order is needless to say.
What is that page number?
Page 84. However, it is expected that the respondents, after considering the relevance and the necessity of the documents sought for by the applicant under Annexure A12, may supply the documents to the applicant as per rules of as per rules of law.
For the praise for those documents, because you have already filed your so-called.
No, I have given them. I had given them at the very outset. I had called for the
No,
document.
but are you stopped from asking for those documents after the inquiry officer?
I have asked.
You are not stopped
Till date. I'll explain to your lordship.
No. After you made it before the authority and after you submitted your show cause, now that document has not been supplied to you.
No, my lords. All those documents which I had asked for, the relevant documents have not been
But did you make an application before the inquiry officer?
I also had made an application before the inquiry officer. That's for the merchants, my lords.
Right.
But since I am before this court, my lords, inquiry officer probably had felt otherwise or whatever, my lords, he could not.
No. Let us be very clear. This order at least shows of the Central Administrative Tribunal that the tribunal made it very clear that if any documents are necessary and that is relevant, then that is to be supplied to you. So after this order was passed, whether in terms of this order you filed any application, you supply me A, B, C, D documents, and these are very much necessary to file an additional reply. You have already filed one reply.
I have filed one reply. The additional reply also could have been filed.
Right. So,
I had asked. The basic documents was, I'll explain to your lordship two aspects to this order and two aspects to the relief that was paid for to perform the tribunal. The document is only one aspect. First aspect was that the entire fact-finding committee, the way it was constituted and the
we just want to know on this particular point. So, if you did not file any application after the order was passed, that means you did not want any further documents from them, or you cannot claim that the reply which has been given at the earliest point of time was insufficient, or I have been debarred from filing any further reply because I was not supplied.
That has been my prayer also, but fully the documents have not been supplied to me.
All right, now the opportunity has been given.
Even after
your side, you should have filed that now.
Even after that, I made an application for the complete set of documents.
Where is that? Which is that letter? After this order was passed,
I'll check
2021, any document was filed from your side that you supply me this particular document, and these documents are very much necessary for filing any additional reply.
That is subsequent allegation 10.
Just a minute. We are asking a question.
I'll check that. I'll check up that. There have been several exchanges of emails.
What that they are for additional documents in after that order was passed by the cabinet.
Actually, kindly come to page 154. These are the trailing emails that I've given to them.
54.
154, annexure C series.
No, that order was passed.
Order was passed on 12/3/2021. 2021.
12/3/21.
2021.
Yeah. Which is the document you are now showing to us? Annexure C.
C series, page 154.
No, it is prior to that.
No, it is prior. It is prior. It is prior, my lords. But this letter was also referred to. Lordship may see the range of documents that I've asked for. I am in receipt of your show cause notice number so and so.
It is all right, but once you have given an opportunity, whether you availed it or not,
that's right. That we want to.
No, I'll just check. I'll just check up. I'm just checking it up, man.
And if your party is here, or you can communicate him just now, we just want to know that whether any other document we want to know, he wants to be supplied or filing any further reply to that. We also want a clear statement from you that whatever has been supplied to you is supplied. If you want any further documents, your party can say that these are the documents which has not been supplied, these are relevant. If at all your party wants now, because the order is very clear.
Because the entire
no, Mr. Palit, just ascertain from your party on this aspect. It's a very one of your submission is this. So
I'll get back to Lordship on this one.
right. We want a statement from you.
Lordship, here the other aspect.
We are not.
This is one aspect, and I'll keep it in mind, and I'll get back to your Lordship on that.
Now, what are the other challenges to that?
Other challenges to the show cause notice itself are minutes twofold. One is minutes that the entire show cause, the fact-finding committee minutes.
The show cause notice.
Show cause notice is.
Have you annexed it?
Yes, it is annexed here. That is at page minutes 79.
Yes.
Page 79 is the show cause. Minutes. If your Lordship minutes gives me minutes one opportunity minutes, I'll place the other part minutes. My contention before your Lordship is this minutes that the entire show cause notice is a facsimile which is based on the report of the fact-finding committee. That fact-finding committee report minutes states clearly indict me. So that is not the purpose of the fact-finding committee minutes inquiry. And fact-finding committee can inquire into the facts minutes for submission before your Lordship, but fact-finding committee cannot deliver a verdict against me. If it goes to that extent and delivers a verdict against me, I have to be given an opportunity. So that opportunity minutes I have been deprived of. And it was my cry from day one, even before the fact-finding committee was constituted, that this is a whole thing, a trap was being laid and it was set up to deliver a fixed finding against me. That your Lordship finds in my letter to the.
No, as it appears from that order which you just show cause notice, it appears that several complaints were made.
Yes.
Right?
Yes.
And by some faculty member of the Department of Pediatric Surgery and also other departments relating to your unprofessional conduct. Okay. So for that reason, a fact-finding committee was constituted. They inquired into the matter. They submitted the report. Now, how you say that they gave a finding? Finding means, in the sense, they are to be preliminary. They are to say that whether these allegations are, as per the complaint, are prima facie appears to be correct or not. They cannot, as you said, you are rightly saying that they should not give their verdict as if you are guilty.
Grateful minutes. That is the.
How you say that they give such type of finding?
I'll just take your Lordship to that annexure minutes, to that page minutes. When the fact-finding committee was constituted, minutes, I gave a. Rejoinder.
So far as this constitution of fact-finding is concerned, I think you have some grievance. One of them is junior, and the other is against you. Means biased against you. That is the averments taken in that. So
I'll take a Lordship to that part. Page check order. Page. Actually, can be, let's go to page 91. What was the scope of the fact-finding committee? In response to my letter which I gave them, that the fact-finding committee appears to be an inquiry against me and my conduct on allegations against me, but there are also allegations which I have made against others. Probably the fact-finding committee is not inquiring into that. That was my first objection. So in reply to that, Ames replies in this. On 11/8/2020, Ames gives a reply, page 91. Point number 2. Inclusion of the Dr. Vivekananda Jindal, HOD, Pediatric Surgery, JIPMAR. In this connection, it is mentioned that the present fact-finding committee is an administrative mechanism to ascertain the facts of the matter to help the competent authority to take some decisions. This is not an inquiry under the CCA rules, and therefore the provisions of CCA rules or the Government of India decision as quoted by Dr. Das will not be applicable. The scope of the fact-finding committee is also further included in the complaints of Dr. Professor Das against other faculty members in the Department of Pediatric Surgery, which places all complaints of the Department of the Pediatric Surgery at similar footing before the fact-finding committee. As the fact-finding committee is not constituted in contemplation of a disciplinary proceeding or pending disciplinary proceedings, the contention of Professor Das that Dr. Jindal, being junior to him, cannot be included in the fact-finding committee is not logical. But this was in direct response to my letter that why is it a fact-finding committee which is only inquiring into allegations against me? If it is a fact-finding committee which is inquiring into allegations against me, then you have a disciplinary inquiry. Come out with a full-blown disciplinary inquiry. You can't have a fact-finding committee where I will not be given any opportunity and others will be examined and you will find me guilty. That kind of a situation should not arise here. That will be to my prejudice. That is also protected. I have my rights under the Constitution are protected. Your Lordship will see how the fact-finding committees, the entire report how it starts. Kindly for your Lordship's appreciation. Type copy. I've given a type copy, this copy.
What is the action taken on the basis of fact-finding committee?
Lordship, kindly. That report. The fact-finding committee. Written. I'm just finding the information. Annexure 9 series is the fact-finding committee report.
Yes, that is with us.
There's a type copy.
73 page. It's not legible.
Yes, I've given a type copy, to your Lordships. Olga, find the Annexure 9. And I've passed on to type copy of the IHS. Annexure 9. Look it up. It looks like this. Huh? Same thing. It's like, it reads like this. Legible type copy of the Annexure 9. Part of the record. Part of the record, legible type copy. Not to be kindly have it. Type copy to the record. Page 73. Page 73. Record was type copy. No, 73 and 76, type copy the देखिए
नहीं
फिजिकली दे दूंगा
पूरा पढ़ी होनी टोटल
नहीं मैं टाइप करके देख लो सर फिजिकल कॉपी
no that is not there.
फिजिकल कॉपी नहीं टाइप करके दिया है ये फिजिकल कॉपी अच्छी है
That is not
अगर इतने छोटो से उड़ा को एक तो लेजिबल नहीं था पर बहुत एकदम
दिस इज द फिजिकली देच टाइप करके
दो ना थी अरे
फिजिकली टाइप करके दोनों को देच
नहीं तो इट सेंड रिपोर्ट में
73
73 to 76.
73 to 76 which one
okay
आगे how the
please please
I am placing this to demonstrate that the entire issue has been pre-decided against me. The report of the fact-finding committee to look into some faculty members of the Department of Pediatric Surgery and others about alleged unprofessional conduct of Professor Kanishka Das, the head of the Department of Pediatric Surgery, AIIMS Bhubaneswar. Now, this is directly in contradiction to that assurance that they have given that the fact-finding committee is not only against you, it is against others also, for your complaint against others. Now, this is the end result is this. The committee was constituted by the President of AIIMS Bhubaneswar, notified on 15th May 2020 and modified on 26th May 2020 with the following members. Chairman Professor Sandeep Agarwala, members Dr. Professor Madhavananda Kora and Professor Vivekananda Jinda, 3 member and convener Professor Sachidananda Mohanty AIIMS. FFC was mandated to take into consideration all the complaints available in the file and also to summon anyone at AIIMS Bhubaneswar connected with the case and record their evidence and to recommend measures for smooth management of the Department of Pediatric Surgery AIIMS Bhubaneswar. The fact-finding committee was provided with copies of various complaints and communications of the faculty members, including Dr. Das, with the President, Director and Administration of AIIMS Bhubaneswar. Also, Professor Das provided additional documents to the chairman on 7th August 2020 after his virtual meeting with the committee. He felt at the time allocated to him was inadequate. These additional documents consisted mostly of the documents already provided by the administration, some of his communications with the other faculty members of the department, and few transcripts of touches on the social media platform. The committee held 3 meetings on the computer facility of the AIIMS Bhubaneswar on the virtual platform and set up computer facility, recorded all the proceedings of all meetings after due information to all the participants. All the 4 members of the committee attended all the 3 sessions. All the faculty of the Department of Pediatric Surgery and Bhubaneswar were allowed to voice their complaints and observations on the behavior and functioning of Dr. Kanishka Das. Dr. Kanishka Das was also allowed to express his remarks on the faculty members, functioning and the department and the perspective on the whole. The faculty members of the other departments who had lodged complaint against Dr. Das were also called and allowed to explain the events and their observation. The timeline of events as perceived. This is important. April 16th to March 18th, Department of Pediatric Surgery AIIMS Bhubaneswar was headed by Dr. Manoj Mahanti, consisted of Dr. Vikas Bihari Tripathi, Dr. Subrat Sahu, Dr. Santosh Mahalik, and Akaspati, and all these and these Akaspati joined the Department of February 2018. March 2018, Dr. Kanishka Das joins as professor and head of the Department of Pediatric Surgery at AIIMS Bhubaneswar. December 3rd, 2018, division of department into 2 functional units by the director. 4th May 2020, director takes over as the administrative head of the Department of Pediatric Surgery. 5th May 2020, setting up of this FFC committee. 25th June 2020, first meeting of the committee members and decided to call all complainants and record their evidence. Now, this was done in my absence. 3rd August 2020, faculty of Department of Pediatric Surgery AIIMS Bhubaneswar were called for evidence. 14th August 2020, faculty of other departments who had complained were also called for evidence. 18th September, recordings of all the meetings and minutes of the meetings provided to the committee members. 23rd September 2020, the report of the FFC was submitted. Then now the report starts. Right from the day that Dr. Kanishka Das joins as professor and head of the Department of Pediatric Surgery, he failed to engage Dr. Manoj Mahanti, the second senior most faculty member, allocating responsibilities and clinical work within the department. Dr. Kanishka Das has questioned the competence and commitment of Dr. Manoj Mahanti towards the clinical outcome, patient care and administrative duties, despite the director himself writing to Kanishka Das in December 2018. This was unfounded and unacceptable. Dr. Kanishka Das continued his adverse behavior against Dr. Manoj Mahanti, seriously affecting his reputation in the department and impeding his clinical and professional growth. Dr. Kanishka Das has blamed the behavior of other faculty of the department on support and guidance given by Dr. Manoj Kumar Mahanti. This behavior against Manoj Mahanti has vitiated the atmosphere in the department. Here, it is pertinent to mention that Dr. Manoj Mahanti successfully steered the new department as HOD for 2 years, from April 16 to March 2018 under his leadership. The department could start the MCH training program and progress in infrastructure development and overall growth. There was a cordial working atmosphere and there were no complaints from anyone within the department or any other department. Dr. Kanishka Das never had severe doubts about the competence of all faculty members of the department. This includes competence in clinical decision making, surgical skills, knowledge of the subject and ability to teach and train. Due to his irrational belief, Dr. Das feels that he is the only competent department person as the HOD. It is his and only his responsibility to uphold patient care and teach in the department. On many occasions, he has questioned patient management by various faculties and even their decisions on surgical procedure and approaches on this account too to the director and counseled him that there may be many ways of managing a patient, and that what Kanishka Das thinks is not only the right way and may not be the only right way. Despite counseled by the director, he has continued in the same way and refused to mend his conduct in the department. He has decided all admissions, all OT lists and scrubbing for all cases. This prevents other faculty from getting independent surgical work and leaves trainees high and dry in the third assistant as the third assistant in surgical procedures. This Dr. Kanishka Das says is the submission. In his submission, he has done to ensure to follow correct surgical procedure protocols against Dr. Kanishka Das does not realize that there are many equally effective surgical techniques for doing the same procedure. It should be the choice of the treating faculty to choose one of his favorites. This has led to the department's low reputation as a training center, and candidates have selected other centers to do their MCH over AIIMS Bhubaneswar. Dr. Kanishka Das, during the head of the department, has prevented the development of minimally invasive surgery in the department and has disallowed or significantly reduced the performance of various procedures that he does not perform. Dr. Kanishka Das has justified this by citing the shortage of OT time without accepting that the OT time will always be short for any surgical unit. Still, the department has to progress on all fronts and areas that he as HOD decides.
This Mahanti is not a member of that.
No, he has in fact deposed against me in the disciplinary inquiry. He has already deposed. That deposition is already over. Now, then the next paragraph.
This will come down to the therefore the various alternative actions suggested in the interest of the department. So, right from the beginning, as the mandate was shown in the fact-finding report, is the one that has been suggested. It has nothing to do with the disciplinary action.
No, I'll tell you, Lordship. Measures recommended for smooth. Yes. The language, Lordship, 77, the language.
That is what.
Dr. Kanishka Das's attitude and method of functioning have not been conducive to teaching, learning, overall progress of either department or the department's faculty members. Despite several bits of advice by administration, He has demonstrated a fixity of ideas in his mind and has failed to discharge and is unlikely to change. His continued presence in the department as HOD or even as faculty member will be detrimental to conducive day-to-day functioning as the department's overall growth. This comes as a part of the observation and the recommendation of the committee, my lords. Measures recommended for smooth functioning. Your Excellency, 1. It seems Dr. Das is still on deputation from his parent department at St. John's in Bangalore. If this is a fact, he may be repatriated back to the institution. Now, this is also not true. 2. He may be removed from headship of the department and the director takes over as administrative HOD for 5 years and the senior-most faculty carries on day-to-day functioning of the department. Dr. Kanishka Das is allowed to continue in the department, but he will need to be isolated and could be isolated, restricted privileges like could be allocated restrictive privileges like sometime in the OPD, a few beds and the OT or some operating time to work as pediatric surgeon. He could be debarred from attending any rounds or any teaching activity or common departmental activities. A resident by rotation could be deputed to work with him. He could function alone if he is not allowed any emergency calls. His involvement in other administrative work outside the department could be decided by the administration. Now, he may be removed from headship of the department and the second senior-most faculty be made head of the department for 5 years and give this time to him for introspection and rectification of his nature. In this time, Dr. Kanishka Das is allowed to continue in the department, but he will need to be isolated. He could be allocated strict privileges like sometime in the OPD, a restricted privileges like sometime in the OPD, a few beds and OT or some operating time to work as pediatric surgeon. He could be debarred from attending any rounds or any teaching activity or common departmental activities. A resident by rotation could be deputed to work with him. He could function alone if he is not allowed any emergency calls. His involvement in other administrative work outside the department could be decided by the administration. Even with this arrangement, if he will not change his stubbornness and continue to jeopardize the growth and create a poor working atmosphere in the department, then he should be debarred from headship permanently. He may be altogether removed from the faculty position at AIIMS Bhubaneswar, or he may be given an option to resign and leave. Now, these are the my lord's recommendations which are in the nature of major penalty. Now, your lordship comes to the my lord's show cause notice.
That means what you, Mr. Palik,
says
that the fact-finding inquiry committee
actually an inquiry
gone beyond the scope of they were to ascertain whether these allegations which have been leveled in the complaint, whether it is prima facie, it is correct or not. These sort of suggestions
language, this shows that the mind has already been made up, whereafter nothing remains for any justice. Then your lordship comes to the show cause. The authority thereafter issues a show cause. Your lordship finds that show cause at page
79.
Exactly. 79. Exactly the same language. With the approval of the competent authority in Bhubaneswar, the undersigned is directed to say fact-finding committee under the chairmanship of so-and-so, so-and-so, so-and-so. Since the day of his joining as professor of the head of the department pediatric surgery, Kanishka Das has
this is altogether a replica. Might be, but you are being given an opportunity or not?
I'll tell you, Lordship, how that is not the opportunity contemplated by the law.
No. How?
I'll tell you, Lordship.
It's a show cause.
Well, I'll tell you, Lord.
Yes.
How you, Lordship.
Yes.
No, whether the first question arises, whether this fact-finding committee was given any authority to propose various alternative actions for internal interest of peace or department. If the fact-finding, or they are to just given to look into the complaint and to find out whether it is a complaint.
Normally, a fact-finding committee happens. A fact-finding committee never gives normally, a fact-finding committee would never give an absolute opinion about somebody's conduct. Because that conduct will be tested in a departmental proceeding. I'm sorry, ma'am.
Yes, yes, you are. Please show us the.
So found to be tried by per state trial, pre-hearing trial has already been conducted.
At that stage, you are not getting.
I am not getting any opportunity. You examined all the faculty members in my absence. I was not given an opportunity to cross-examine any one of them. This itself is announced to denial of principles of natural justice. I cite
fact-finding committee.
Yes. If you are in the fact-finding committee, I normally need not.
Sir.
No, I need not. Kindly allow.
Just.
If I need not, but if you are rendering a finding against me, my lords,
no, basing on that, if an action is contemplated and you are not given opportunity, then you
I will tell your lordship. Action is contemplated. This is the show cause.
Yes.
Show cause is an exact replica of the mallards report.
Yes.
Now, mallards, grateful mallards, I'll take your lordship to the judgment.
Yes.
Which I cited before the tribunal, and also I am citing before your lordship. Mallards, this mallards more or less settles the legal position. Take out Orix. Very lucidly, manner this judgment articulates.
Yes.
The scope of fact finding inquiry.
Where the violation happens.
Right. Please.
I've given a citation. I've given that citation.
This Union of India versus.
No, Orix Fisheries Private Limited versus Union of India and others.
That is it.
That is at the end. That compilation you actually find at page 40. Page 40, yes. Page 40 of that compilation. 2010, volume 13, SCC, page 427.
Okay.
Okay. Volume 13 SCC, page 427.
Private Limited.
This is the leading judgment. I'll tell your lordship, your lordship may kindly permit me to place this judgment at some length, so that the entire perspective can be.
Anything stated in that about the fact finding, the scope of fact finding? The scope of fact finding.
No, nothing has been stated. That is not. There is nothing regarding the scope of the fact finding committee.
Because after receipt of the complaint, the fact finding committee was constituted to ascertain the correctness of the in a prima facie. So whether at that stage the fact finding committee is to give a verdict that he is like this, is like that, he should be punished like that. So that is whether that would be beyond the scope.
That cannot be given.
That
cannot be given. Right, cannot be given. Your lordship will find, the lordship will appreciate from reading this judgment, it says what a show cause should or should not do.
Yeah.
Here, your lordship has already appreciated that the show cause is a facsimile of that fact finding committee report. Exact language, the verdict. Fact finding committee delivers a verdict against me. And that verdict has been copied in the show cause notice, and a show cause notice has been issued against me. Now, against such a show cause notice, what relief do I have, or how am I prejudiced? This is what this judgment talks about. For
22.
Para 20, in the backdrop of those facts, the first question which falls for our consideration of this court is whether the respondents in cancelling the registration certificate of the appellant acted fairly and in compliance with the principles of natural justice, and also whether the respondents acted with an open mind. Page para 20. These are the requisites. Whether your mind should be open and you act with principles, fairness and principles of natural, in compliance with the principles of natural justice. Paragraph 20. Let's go on that paragraph.
But this is not in consonance with any inquiry, no? Departmental inquiry.
No, it is.
This is in a trade matter, no?
No, maybe a trade matter, but how your show cause is to be.
No, but there are a number of cases in disciplinary action. There are a number of cases in disciplinary actions.
Yes, disciplinary action, there are cases. This mallards, most humble and most respectful submission mallards, this lays down the platform
All right.
Your Lordship will see paragraph 20. If Your Lordship is
Yes.
in background of these facts, the first question which falls for consideration of this court is whether the respondents in cancelling the registration certificate of the appellant acted fairly and in compliance with the principles of natural justice, and also whether the respondents acted with an open mind. 21. It is obvious that in passing the impugned order of cancellation, the respondents were acting in a quasi-judicial capacity, and also they were acting in exercise of their statutory powers. Indisputably, the third respondent, while purporting to cancel the registration certificate, was acting in exercise of powers under Rule 43 of the MPEDA Act rules. The show cause notice dated 29/1/2008 was issued by the third respondent in exercise of this power. For a proper appreciation of the points involved, the show cause notice is set out in extensio. Subject show cause. Your attention is invited to our headquarter letter number so-and-so dated so-and-so and subsequent joint meeting with the buyer held in our head office on 5/9/2007 on the trade complaint received from Messrs. Cascade and Marine Foods LLC Sharjah. At the meeting, it was convincingly proved that the cargo shipped by you to the aforementioned buyer, now the language would be, the important words are convincingly proved to you by the aforementioned buyer was defective, and you have not so far settled the complaint. Therefore, in exercise of powers vested in the office order number so-and-so, read with so-and-so, I hereby call upon you to show cause while the certificate of registration is as an exporter granted to you should not be cancelled for the reasons given below. Before that, they say convincingly proved. That is how the show cause manner starts. It has been proved beyond doubt, again reiteration, that you have sent substandard material to Messrs. So-and-so, Sharjah. You have dishonored your written agreement with Messrs. Cascade Marine Sharjah to settle the complaint made by the buyer, as you had agreed to compensate to the extent of the value of the defective cargo sent by you, and you have now evaded from the responsibility. The irresponsible action you have brought, this irresponsible action has brought irreparable damage to India's trade relations with the UAE. Your reply should reach the undersigned within 10 days from the date of receipt of this letter, failing which it will be presumed that you have no explanation to offer, and we will proceed with the action for cancellation of your registration certificate without further notice to you. If ultimately a decision is reached to deregister you, under the provisions of the MPDA rules, it will automatically entail deregistration under the registration exporters policy also. Now here also they say if ultimately we reach a decision, this ultimately the Supreme Court finds is entirely, it is a knowledge, it has been made up. Relying on the underlying portions of the show cause notice, the learned counsel for the appellant urged that even at the stage of show cause notice, the third respondent has completely made up his mind and reached a definite conclusion about the alleged guilt of the appellant. This has rendered the subsequent proceedings as an empty formality and an empty ritual and an ideal formality. This court finds that there is a lot of substance in the aforesaid contention. It is well settled that a quasi-judicial authority, while acting on exercise of its statutory powers, must act fairly and must act with an open mind while initiating a show cause proceeding. A show cause proceeding is meant to give the person proceeded against a reasonable opportunity of making an objection against the proposed charges indicated in the notice. Expression like a reasonable opportunity of making objection or a reasonable opportunity of defense have come up for consideration before this court in the context of several statutes. A constitution bench of this court in Khemchand versus Union of India, of course, in the context of service jurisprudence, reiterated certain principles which are applicable in the present case also. Justice S.R. Das C.J., speaking for the unanimous constitution bench in Khemchand, held that the concept of reasonable opportunity includes various safeguards, and one of them, in the words of the learned Chief Justice, is an opportunity to deny his guilt and establish his innocence, which can only be done if he is told what the charges leveled against him are and the allegations on which the charges are to be based. It is no doubt true that at the stage of show cause, a person proceeded against must be told his charges against him so that he can take his defense and prove his innocence. It is obviously at that stage the authority issuing the charge sheet cannot, instead of telling the charges, confront him with definite conclusions of his alleged guilt. If this is done, as has been done in the instant case, the entire proceeding initiated by the show cause notice gets vitiated by unfairness and bias, and a subsequent proceeding becomes an idle ceremony. This is what I have been emphasizing. So what the show cause notice does is to confront me with the allegations that you are doing this, you are this, you are that, you are this, you failed to do this, you failed to do that. So thereafter, after your mind is made up, your lordship has sufficient experience in minutes, vast experience, far outstripping mind minutes in this way minutes, how mind is made up. That minutes, after that, what relief can you get in that forum? What the fact-finding committee should have done is should have restrained itself, should have heard both sides and said that yes, there appears to be some kind of a dispute among parties. Let it be. If the governing body so wants, it can institute a disciplinary proceeding to enter. Instead of doing that, what the fact-finding committee does is, it straight away gives me a litany of indictments. Each paragraph starts with an indictment against me. Dr. Das has done this, Dr. Das is this, Dr. Das, and I'll take a short departure here. I am before coming to this Ames I came because my old parents were here. I was one of the top 3, and I still am one of the top 3 pediatric surgeons in the country. In St. John's, they used to have my appointment list was more than 7 days to meet. And one of the most celebrated council and doctors. And my father was one of the most celebrated brain surgeons in the Asia. My family of doctors, I came to take care of my old parents. And then, so that the department can be set up. Yes, I am a disciplinarian, and you never achieve excellence without being a disciplinarian of some sorts, So I have come with that intention. It is not that I am here for money or doing anything. I could have gone abroad, I could have earned money. It is not that, I have come here to help the state. And because it is my state, I have come here. And now, this has become a cesspool of political gambits. And now, this is how they have treated. And can this proceeding, any justice arise from this proceeding, here? What issues I have or not have with the faculties can be settled out in different forums. And you have already removed me from headship. You have held in the show cause. This you have done. And it has been my cry from day one. And your lordship will see, I have I'll just
fact-finding committee was modified only after your application, because Mr. Mahal had also did.
Yes, it was modified only after I said you have a fact-finding committee against me. If it's a fact-finding committee against me and me alone, have a disciplinary inquiry. Why a fact-finding committee?
And who was one of the members in the committee?
Oh, no, I'm not there. Manju has come and deposed against me. That's a different story, Malad. That's a different story. Now, I'll just take a little further with this judgment, Malad.
No, we are keeping, Mr. Khalid, let us be clear on this. Jone doctor ko nare, let us say complaints were received. जे से ठीक समय हॉस्पिटल को आसुनांती से रोगी मानक खराब व्यवहार करचंती प्राइवेट हॉस्पिटल को जीवा पाई से प्रोत्साहित करते गोटे एग्जांपल आप एवं एई टाइप रो कंप्लेंट आसिला एवं फैक्ट फाइंडिंग करबा को ए कंप्लेंट प्राइमा फेसी ठीक अछि ना नाही अभियोग देखिबा पाई फैक्ट फाइंडिंग कमिटी गोटे कॉन्स्टिट्यूट करा गला से माने जो माने अभियोग करथिले तांको एग्जामिन कले एग्जामिन कला परे सेमाने बाय द वे सेमाने सजेशन देले जे एभली डॉक्टर चाकरी रे रहिबा उचित नै ताकू इमिडिएटली चाकरी रो बर्खास्त करिबा उचित तानारे क्रिमिनल प्रोसीडिंग करिबा दरकार एई टाइप रो तार जो टंका नै छि दरमार रिकवरी करिबा दरकार एई टाइप रो अपार्ट फ्रॉम दैट एई टाइप रो केते गुडा को ये देले सो व्हाट वी वांट टू नो दैट एभली जदी कोटे फैक्ट फाइंडिंग इंक्वायरी फाइंडिंग्स देबे whether that is within the scope of fact finding inquiry or they have gone beyond their scope.
They have to identify the scope first.
Please tell us. I'm going example that. So,
Again, I'll just if your lordship permits me to read a little more of this judgment, my lords, the entire expanse of this judgment. Thereafter, my lords, I'll try to endeavor to do my best to, my lords, explain to you.
प्राय केसटा एई टाइप रा
What is the case about?
आपणकर नारे किछि अभियोग आसिला से अभियोग को जेतेबेले पचारिले एटू जाय टाइप रो फाइंडिंग्स देले जा बेसिस रे आपन को शोकज नोटिस हला सेगुडा को आपन को वर्चुअली माने जेंति एज इफ दे हैव फाउंड यू गिल्टी under that
Absolutely.
Under a complete bias.
Complete bias.
That should not have been the
That cannot be.
that is not the duty of a fact finding.
That will not be duty. That
you have
only
to just see that yes, he complaint गुड़ा का prima facie ठीक की ना है.
prima facie there appears to be something even
press तांकु छाड़ देवे.
open mind.
सेमाने तांकु ताधरे initiate करीबे कि नहीं departmental procedure.
Let them have an open mind. You can recommend. And in fact, I have already been removed from headship. Headship I have already been removed. Then there's two more paragraphs in this. Justice is rooted in confidence, and justice is the goal of a quasi-judicial proceeding also. If the functioning of a quasi-judicial authority has to inspire confidence in the minds of those subjected to its jurisdiction, such authority must act with utmost fairness. Its fairness is obviously to be manifested by the language in which charges are couched and conveyed to the person proceeded against. This is very important, my lords. In the instant case, from the underlying portions of the show cause notice, it is clear that the third respondent has demonstrated a totally closed mind at the stage of show cause notice itself. Such a closed mind is inconsistent with the scheme of the rule so and so, which is set out below. The aforesaid rule has been framed in exercise of power so and so.
You say that the show cause is based on that those findings which has been arrived at by the fact finding inquiry committee.
I don't say that the show cause reads.
It's just a replica.
It doesn't read by saying so. It reads. Then your lordship will see paragraph 31. It is true that the show cause notice cannot be read hypertechnically, and it is well settled that it has to be read reasonably. True. But one thing is clear, that while reading a show cause notice, the person who is subject to it must get an impression that he will get an effective opportunity to rebut the allegations contained in the show cause notice and prove his innocence. If on a reasonable reading of the show cause notice, the person of ordinary prudence gets the feeling that his reply to the show cause notice will be simply an empty ceremony, and he will merely knock his head against a impenetrable wall of prejudged opinion. Such a show cause notice impenetrable wall. I'll just start once again. But one thing is clear, that while reading a show cause notice, the person who is subjected to it must get an impression that he will get an effective opportunity to rebut the allegations contained in the show cause notice and prove his innocence. If on a reasonable reading of the show cause notice, a person of ordinary prudence gets the feeling that his reply to the show cause notice will be an empty formality ceremony, and he will merely knock his head against an impenetrable wall of prejudged opinion, such a show cause notice does not commence a fair procedure, especially when it is issued in a quasi-judicial proceeding under statutory regulation which promises to give the person proceeded against a reasonable opportunity of defense. Therefore, while issuing the show cause notice, the authorities must take care to manifestly keep an open mind, as they are to act fairly in adjudging the guilt or otherwise of the person proceeded against, and especially when he has the power to take a punitive step against the person after giving him a show cause. He who has the power has to act most carefully, my lords. The principle that justice must not only be done, but must eminently appear to be done as well, is equally applicable in quasi-judicial proceedings. If such a proceedings is to inspire confidence in the minds of those who are subjected to it. And then, my lords, it proceeds on various other. And therefore, my lords, the entire argument laid by the my lords Ames is this, my lord, in their counter. Counter, they are saying, they filed a preliminary counter affidavit. Where, my lords?
Yes. Page 111.
My lords, page 111. Grateful, my lords. Page 120.
120.
120. This is their stand in the counter.
Yes.
The fact-finding committee, as mentioned in the office order number so and so, was directed to ascertain a few facts and veracity of several complaints submitted by some faculty members of the department and other departments about the alleged unprofessional conduct of the present petitioner as HOD of the Department of Pediatric Surgery, and to examine whether the present petitioner has failed to provide guidance and leadership as expected from the petitioner as head of the department. Now, here, the cat is out of the bag. The fact-finding committee was constituted only to examine against me. Earlier, my lord, I started with their saying, while they denied me, my lord, that the scope has been expanded, it will also, there will be an inquiry against you and also against others. Now, here is the cat is out of the bag. Further, as stated in the office order dated so and so, FSC was directed to take all the complaints as available in the file into consideration and may summon any one of the institute in Bhubaneswar who are connected with the case and record their evidence. If felt necessary, FFC was also directed to recommend measures to be taken for smooth management of the Department of Pediatric Surgery. Under smooth management, they can't include punitive measures. That surely cannot be in the scope of recommending measures.
Complaints which you have received, that is not only against you, it is on various issues.
Various issues.
That is why they should have inquired into all the things.
All the things.
It is not that they just, by filing this counter, they have stated that so and so was constituted to examine whether the petitioner has failed to provide the.
And also, before that, your lordship will come to page 120.
Yeah.
On bold, they are written. How the counter has been drafted, my lord. Departments bold about the unprofessional conduct of the present petitioner. As if this is the only thing that is being inquired into. This is bold letters. When we do it in our
the basis of the complaint that has come.
What is bold about it? If there are other issues to be examined, we could have also underlined those portions. Then further, and then the FFC was also directed to recommend measures. By virtue of the office order so and so, it was also directed to inquire into all such complaints, information that made by the present petitioner against faculty members, on which are on record in addition to the existing scope so and so. Thus, the FFC was directed to ascertain facts regarding allegation made and also allegation made against the present petitioner. There was no biasness or malafide in the constitution as alleged. The FFC was constituted with a defined scope of inquiry with objective of finding truthfulness of the allegations and recommending measures to be taken for future smooth functioning of the Department of Pediatric Surgery, as there are various internal issues among faculty members of the department which were hampering the smooth management. And then they say FFC was not an inquiry under the CCS rules, and therefore the provisions of the CCS rules and acts will not apply, and therefore this. And then, my lords, I have stated in my rejoinder as a reply, the lordship will see. Page 142. Page 142, I have crystallized these things. There were several allegations against the petitioner means to ascertain the veracity of the FFC, their veracity. Page 142, my rejoinder, my lords. These facts, my lords, emerged from the counter affidavit. If your lordship will come to page 142.
Yes, yes.
There were several allegations against the petitioner. Hence, to ascertain their veracity, first point, the FFC was constituted. But the FFC takes on the character of an inquiry by summoning witnesses and recording their evidence. All this was done behind the back of the petitioner. 3. That the FFC was instituted, and after conclusion of the inquiry, the FFC report was placed before the governing body to obtain post hoc approval. That the governing body concluded that the findings against the petitioner by the FFC were very serious and needed initiation of disciplinary action. That the FFC report was accepted by the governing body in total. That the FFC report, FFC has given definite recommendations which are penal in nature against the petitioner. That the penalty suggested by the FFC has already been implemented or worked out. The FFC report was made the basis for issuance of a show cause against the petitioner. The disciplinary authority considered the reply of the petitioner, and the said reply was found to be unsatisfactory. Hence, the issuance of articles of charges along with statement of imputations against the petitioner. These are natural consequences which flew from that, my lords. But the whole thing, my lords, in my most humble and most respectful submission, my lords, has been contrary to any all established norms of natural justice, principles of natural justice. And the whole thing is biased, man. They've already made up their mind. Because they will be the authority ultimately to impose the punishment. So if you are already your language of the show cause is such that I can see my guilt, my lord, shining through, indictment shining through. I will not say guilt at this stage, it is indictment. Then what remains? And then, my lord, the Supreme Court has also laid down, my lords, in another judgment, my lords, I would like to draw your lordship's attention to 1989-1, SCC, page 764, that have, wait a day. Well, I'm sorry, I just had one copy. If your lordship permits, can your lordship, my lords?
All right.
I'm passing on one copy, my lords. Your lordship may not take me amiss, my lords. The famous judgment, my lords, H.L. Trehan and others versus Union of India, my lords, where the entire plea that they will take is, my lords, that it is, we are giving you an opportunity in the, my lords, in the disciplinary proceeding. So therefore, this is an answer. This Supreme Court judgment is an answer to that sort of an argument that they are going to advance, my lords, is this. Para 12. It is, however, contended, paragraph 12, my lords. Here, my lords, this judgment says, first decisional hearing is no hearing in the eye of law. Any hearing, my lords, there has to be, my lords, it is, however, contended on behalf of CORAM that after the interim circular was issued, an opportunity of hearing was given to the employees with regard to the alterations made in the conditions of their service by the interim circular. In our opinion, the most decisional opportunity of hearing does not subserve the rules of natural justice. The authority who embarks upon a post-decisional hearing will naturally proceed with a closed mind, and there is hardly any chance of getting a proper consideration of the representation at such a post-decisional opportunity. Well, actually, I view this in stark contrast with the show cause that has been issued to me. In this connection, we may refer to a recent decision of this court in K.L. Shepherd versus Union of India. What happened in that case was that the Hindustan Commercial Bank, the Bank of Cochin, and Lakshmi Commercial Bank, which were private banks, were amalgamated with Punjab National Bank, Canada Bank, and State Bank of India, respectively, in terms of separate schemes drawn under Section 45 of the Banking Regulations, 1949. Pursuant to the schemes, certain employees of the first mentioned three banks were excluded from employment, and their services were not taken over by the respective transferee banks. Such exclusion was made without giving the employees whose services were terminated an opportunity of being heard. Ranganath Mishra J, speaking for this court, observed as follows. We may now point out that the learned single judge for the Kerala High Court has proposed a post-amalgamation hearing to meet the situation, but that has been vacated by the division bench. For reasons we have indicated, there is no justification to think of a post-decisional hearing. On the other hand, the normal rule should apply. It was also contended on behalf of the respondents that the excluded employees could not be represented and that cases could be examined. We do not think that would meet the ends of justice. They have already been thrown out of employment, and having been deprived of their livelihood, they must be facing serious difficulties. There is no justification to throw them out of employment and then give them an opportunity of representation when the requirement is that they should have the opportunity referred to above as a condition precedent to the action. It is common experience that once a decision has been taken, there is a tendency to uphold it, and the representation may not yield any fruitful result. This view has been taken by the court in the above observation, and once a decision has been taken, there is a tendency to uphold it, and the representation may not yield any fruitful result. Even if any hearing was given to the employees of CORAM after the issuance of the improved circular, that would not be any compliance with the rules of natural justice or avoid the mischief of arbitrariness as contemplated by Article 14 of the Constitution. The High Court, in our opinion, is perfectly justified in quashing the improved circular. So therefore, my lord, these are my submissions before your lordship. But you can't already decide. So therefore, this judgment, and read with my lord's Oryx refines this concept even further in my most humble and most respectful submission. But to truly bring in a color of an impartial inquiry, right from its inception, the show cause itself should appear to be absolutely neutral. Because ultimately, what they hold the power to punish me. So once the show cause itself managed to demonstrate that you have already closed the mind, basing on a fact-finding committee inquiry report, which is already nothing but a litany of indictment against me, and which has recommended measures which have already been implemented. The last measure that he may be removed from the faculty altogether is only pending here. I have already been taken off. My scrubbing, my OT time, hours have been limited, my everything, all the measures, including my removal from headship, that have already been done. So now only that removal from the faculty means you terminate me. I am the dog and give him a bad name. That is what my lords they say. And this is how, my lords, the authorities have proceeded.
Yes.
This can't find sanction, my lords, in any civilized or sensible rules of any department, least of all the central government rules, my lords. Great respect, my lords. I'll have a right to reply, my lords, as a matter of rejoinder. Great.
That para 29.
No, first of all, tell us that these complaints which you have received, that is only against the conduct of this man or against so many issues?
Especially, my lord, due to his disturbance in the department, my lord. What happened actually?
When he has pointed out that the fact-finding inquiry was conducted to ascertain this so many complaints have been received.
Allegations.
No, it is not only against him, but on so many issues. So why this? They thought it proper only to this inquiry into the conduct of this man.
Actually, what is the
You have filed your
Problem.
counter affidavit, na?
Yes.
In your counter affidavit, he has pointed out. Just see that counter
I'll
affidavit.
come to that, my lord.
Uh-huh.
First, my lord, finally have a glance to page 29.
29 of
29 of the
brief.
Yes.
Uh-huh.
Well, disturbance arose here, man. What happened actually? The department was bifurcated, man. And in one part, in one unit, man, kindly have a glance to last part, pediatric surgery, man. In that unit 1 and unit 2, there are 2 units. In one unit, one is Dr. Kanishka Das was the unit head, and in another, unit 2, Manoj Kumar Mahanti was the unit head. The disturbance arose here, man. And he deliberately, man, if your lordship kindly see the brief under Annexure 4 series, he repeatedly wrote the emails. And for which the smooth operation of the department, there are certain allegations and
page which you are showing, that is an office order.
Yes, sir.
In that office order,
for smooth functioning of the department.
Just a minute. Office order re, upon jo unit 1, unit 2 dekhauchanti, that is at page number 29. It indicates that unit 1 re, this petitioner, Dr. Kanishka Das, was the unit head, right?
Yes, sir.
And his days are this Monday, OPD days are so, and OT days are so, right?
Yes, sir.
And unit 2 is completely different. That means that is Tuesday, so that is Manoj Mahanti was unit.
Yes.
So how do you say that this is?
No, actually what happened, he is against Manoj Mahanti. Dr. Kanishka Das, from the beginning he is opposing Dr. Manoj Mahanti, and he has also challenged his appointment. There are certain allegations are
where he has challenged.
The reason based known to him.
No. Where has he challenged? Whether before you or what?
Here,
you are speaking for Union of India or you are speaking for Manoj Mahanti?
No, Miller.
Then
all the facts should be played.
Actually, what use koluchan? Actually, empty heichi. As if you are Manoj Mahanti.
He has sent the mail to the department. যে তার ଯୋଉ appointment illegal, ସେ eligible ନଥିଲା, ତାକୁ appointment କରାହେଲା. Those points he is raising. Thereafter,
you can say that the read between 2 doctors has given rise to this problem, and ultimately the institution is at stake. But how can we take the...
And this is one of the ground of our counter. If you are challenging the being allegation against that Dr. Manoj Mahanti, you have not made a party. So it is also due to non-gender and misgender parties that person is liable to be dismissed. First thing. Second thing, my lord, at page 29 I have shown. Thereafter, my lord, kindly come to page 72, my lord. Page 72. Thereafter, this order, 15/5/2020, this departmental office order has been issued regarding revised administrative arrangement of the Department of the Pediatric Surgery. The existing second parameter, the existing 2 units of the Department of Pediatric Surgery, that is one unit headed by Professor Kanishka Das and another unit headed by Dr. Manoj Mahanti, will independently report to the director for all administrative and academic matters of their respective units in place of Dr. Das as HOD. However, Dr. Das and Dr. Mahanti will continue to manage independently. But kindly have a glance to this wording, matter. In order to for smooth functioning of the department, so the department has given importance to both of them. So no one has been deprived. So they given the independent charge of 2 units. One unit is Dr. Kanishka Das and another is Mr. Manoj Kumar Mahanti, Dr. Manoj Kumar Mahanti. Thereafter, kindly have a glance to my page 73 of the fact-finding committee. Annexure 9, what my learned was placed. The report of the fact-finding committee, this was with the due approval of the competent authority.
a committee was constituted and the allegations were inquired into. But at this stage, the fact-finding committee has submitted its report, madam. Thereafter, madam, what my honest senior was submitting, he was not given an opportunity, but it is the initial stage, and the allegations are against him. So, after a fact has been brought out by the committee, thereafter we have given issued the so-called notice, which is also at annexure page 79, 4/2/2021, on the first line, can we have a glance? With the approval of the competent authority, M. Subhanesh, and the director has issued that so-called notice. So, in this so-called notice, he has given an opportunity to raise his case. And at the stage of fact-finding committee, there is no need of giving opportunity for cross-examination. This is as because it is not a disciplinary proceeding, and after so-called he will give his reply. Then at different levels, opportunity will be given. What is the mandate of law? So, there is no illegality or wrong committed by the authority in issuing this so-called notice. And what my learned senior was submitting, he has given a reply, and that was declined, and charge sheet was also issued to him. So, it is the premature stage. At this stage, this petition should not be entertained. As because after charge, the prosecution evidence or defense evidence should be recorded by the authority. Inquiry officer will be appointed. Then inquiry report will be submitted. So, this is the premature stage where petition should be entertained.
এইটা যে ଆପଣ କହିଲେ just ଏ ଯୋଉ କାଉଣ୍ଟର affidavit କୁ ଆସିଲେ ଆପଣଙ୍କର
Yes, sir.
paragraph 9.
Yes, sir.
9 of page 120 page को आसନ୍ତୁ but 120 page ର new page. Further, it is humbly submitted.
Further, it is humbly submitted that regarding
certain alleged complaints
of some faculty members of the Department of Pediatric Surgery and other departments about unprofessional conduct of the present petition, as the head of the Department of Pediatric Surgery, as enumerated in the report under Annexure 9 of the petition, the competent authority, that is the President M. Bhubaneswar, by virtue of the office order dated 15/5/2020, and the office order dated 22/5/2020, constituted a fact-finding committee under the chairmanship of Professor Sandeep Agrawal, Department of Pediatric Surgery, AIIMS New Delhi, and other members being Professor Madhavanandakar, HOD, Department of Surgical.
So say जो annexure C/2 series study आसे देखिए अपन जोड़ा annex करछन ना true copy of the office order.
Yes.
सेठी आसन.
Yes, sir.
कितने पेज रचे ना?
No, 135.
135. Oh, 135 questions.
Yes.
Please read it out. That is 15/5, huh?
Subject 15/5/2020. Fact-finding committee to look into the complaints of some faculty members of the Department of Pediatric Surgery and other departments about alleged unprofessional conduct of the Professor C.DASH as the HOD Pediatric Surgery. The President, AIIMS, Bhubaneswar, has constituted the following fact-finding committee to ascertain the facts of several complaints submitted by some faculty members of the Department of Pediatric Surgery and other departments about alleged unprofessional conduct of Dr. Kanishka Das as the HOD of the Department of Pediatrics Surgery, and to examine whether Dr. Das has failed to provide guidance and leadership expected of an head of department besides a cohesiveness and team spirit that is expected in any department. Chairman, Professor Sandeep Agrawal, Department of Pediatric Surgery, AIMS New Delhi. Member, Professor Madhavanandakar, HOD, Department of Surgical Oncology, AIMS Bhubaneswar. Member Convener, Professor Sachidananda Mahanti, Medical Superintendent, AIMS Bhubaneswar. The FFC shall take into consideration all the complaints available in the file and summon anyone in AIMS Bhubaneswar connected with the case and record their evidence as felt necessary. The FFC may also recommend about the measures to be taken for future smooth management of the Department of Pediatrics.
So, ये जो आपण जो फाइंडिंग का देले आपनकर फैक्ट फाइंडिंग इंक्वायर आपण जो अथॉरिटी दिया इतला आपण को FFC may also recommend about the measures to be taken for future smooth management of the Department of Pediatric Surgery. सेही ପାଇଁ एगुडा के देले बेटी कहउछ फैक्ट फाइंडिंग इंक्वायर जो जोड़ा मिस्टर पालित प्लेस करले. Please come to that once again. Page 100 केते
that is page 73 start.
73 जोटा
73 or 80 पढ़े सुन
78 page. Finding is the 78.
77 where अच्छी से
He may be removed from headship of the department and the second senior most faculty be made the head of the department for 5 years and gave his time to him for introspection and rectification of his nature. In time, Dr. Kanishka Das is allowed to continue in the department, but he will need to be isolated. He could be allowed restricted privileges like sometime in the OPD, a few beds and a OT or some operating time to work as pediatric surgeon. He should be debarred from attending any rounds or any teaching activity or common departmental activities. A resident by rotation.
What is the page number which you first placed that
78
to FFC raw?
It starts from 73. It starts from 73 connection line. FFC.
No, अपन जो फैक्ट फाइंडिंग इंस्टीट्यूट जो
mandate
करे कौन को भी
page 135
Page
135
document counter.
Annexure C2.
That is dated 15/5/2020.
Yes, ma'am. 15/5/2020. Can you place that?
ऐसे last line तक ठीक है.
Last line. The FFC shall take into consideration all the complaints as available in the file and summon anyone in AIMS Bhubaneswar connected with the case and record their evidence as felt necessary. The FFC may also recommend about the measures to be taken for future smooth management of the Department of Pediatric Surgery. Further, my lord, I am really want to submit here that this order is also, my lord, challenged by the petitioner before the Learned Cat in OA number 450, 451 of 2020. That is still pending. I have taken at page 117 of my counter, my lord. Kindly have a glance. Page 17. 117, my lord. 117. Second para. Further, it is relevant to mention here that the issue relating to illegal appointment of Dr. Manoj Kumar Mahanti as additional professor, Department of Pediatrics at AIMS Bhubaneswar, as alleged by the petitioner, The same is under adjudication before this honorable court in WPC PIL number such and such. For the acceptance of their request. And the present respondents have also submitted the reply in their case. The matter is pending for adjudication before this honorable court. Further, the present petitioner has also raised the same issue regarding illegal selection of Dr. Manoj Kumar Manti as additional professor, Department of Pediatrics before the learning Administrative Tribunal, Kotak bench, Kotak in OA number such and such. Wherein it was also challenged 15/5/2020. And the petitioner has alleged the power of the director, and wherein regulation 11 of the AIMS regulation, 1999, there is clearly he can issue.
Can I clarify my notes?
Yes.
The PIL was filed not by the petitioner, but by somebody else. It was a co-warrant to proceeding, which was disposed of by the Honorable Court that since already the issue regarding the headship is pending for the CAT, so therefore the PIL is disposed of in that line. That was disposed of, no longer pending. And the CAT is a direct 1:1, whatever is happening.
So at this stage, the petitioner could not be agreed, because there are no inquiry report has been till yet submitted by the inquiry officer, and evidences to be recorded. So at that stage also he may participate and raise his all these contentions. That should be considered by the authority during disciplinary proceeding. And fact-finding committee has not been initiated under CCA rules, my lord. That is mere preliminary inquiry made by the authority. So ultimately, what action would be taken or will be taken in the disciplinary proceeding, my lord. And now the petitioner in no way has been prejudiced. It is a premature stage. So how we will presume on assumptions and surmises, madam? If the petitioner at all agreed, he may challenge the charge. What charge has been leveled against him?
Yes, what do you say? And for the opposite party number 2 and 3, I prepared a date check for your lordship's. Yeah.
Well, he could not appear, man. I have also that objection. My objection will be recorded.
No, wait. So we have already taken a decision that we will be giving opportunity to both. We are not going to resolve this issue here.
No, that is the circular also.
All right.
It's all right. That you have stated, we are hearing the matter. Yes. Synopsis date check.
Please use the mic properly.
Yes. In this rate petition, Annexure 10, the order passed by the Learned Cat, and to quash Annexure 9, the show cause notice as well as the preliminary inquiry report, that is FFC report. 2018, the petitioner joined AIMS in the Department of Pediatric Surgery. On 5/11/2018, many complaints received regarding deteriorated work atmosphere in the department. For better and smooth functioning of the patient care service, bifurcation of the department, including other departments, were made. Annexure 3 series of the writ petition
which lie squarely within the domain of the competent authority, Regulation number 11 of the EMS, Regulation 1999, Annexure BY2 to the counter, and 15/5/2020, a FFC consisting of 4 members were constituted to inquire into the complaint received and to recommend the measures to be taken for smooth management. 22/5/20, by virtue of the order of the FFC was directed to inquire into the allegations made by the petitioner and also the allegation made against the petitioner, Annexure C/2 series of the counter. 23/9/20, the FFC submitted its report, Annexure 9 to the writ petition. 16/12/20, the same report was placed before the 7th meeting of the governing body, which was approved, and the decision was taken to issue show-cause notice to the petitioner for his various alleged misconduct. 4/2/21, a show-cause notice was issued to the petitioner directing to submit his reply, Annexure 9 to the writ petition. 12/3/2021, being aggrieved the petitioner approached the Lawrence Court by OA number so-and-so, which was dismissed being devoid of any merit. 5/4/21, agreed by the same, the present writ petition has been filed. During pendency of the writ petition, the petitioner submitted his reply to the show-cause notice dated 4/2/2021, Annexure 9 to the writ petition. 5/11/21, this Honorable Court, while issued notice to the opposite parties, as an interim measure, passed the following order. As an interim measure, it is directed that the proceeding initiated by the opposite party number 2 on the basis of Annexure 9 may proceed, but no final order shall be passed without leave of this court. The order shall be effective till the next day. 17/12/21. The disciplinary authority, having not been satisfied with the show-cause reply filed by the petitioner, issued charge memo along with the articles of charges and statement of imputations of misconduct, and directed to submit his written statement of defense. Thereafter, under Rule 14 of the CCA Rule 1965, appointment of inquiring authority and the presenting officer have been made, duly ratified in the 11th meeting of the governing body. Now the present status of the inquiry. Out of total number of 22 witnesses from both sides, 21 witnesses have already been examined and cross-examined by both sides. One management witness could not appear and requested the inquiring authority to submit his evidence in writing, which is under consideration by the inquiring authority. Further, the petitioner's request for re-examination of 2 management witnesses, which is pending for consideration by the inquiring authority. In that view of the matter, the Honorable Court ought to be pleased to defer the hearing of this case till fully compliance of the order dated 5/11/21 for the interest of justice, equity, and fair play. Yes. Now, only 2 management witness, he is to file his evidence in writing, and decision to be taken for re-examination of the 2 managers. That is the position of the agent.
This particular line which you have mentioned in that is 22/5/2020.
Yes, sir.
Whether it is factually correct?
By virtue of this order, FFC was directed to inquire into allegation made by the petitioner and allegation made against the petitioner, yes, that is.
We see that page number 135, that is Annexure C/2.
That is the order line. Yes.
So, the order upon लिखले FFC was directed to inquiry into the allegation made by the petitioner.
Yes. And the allegation made against the petitioner.
By and against.
And in my, your lordship, I will find. I have.
से office order देखुनांती 15/5/20 रे it is against the petitioner लिखा है. So by the petitioner कोडी अछि आपण inquiry करिया ପାଇଁ.
So that is against the petitioner.
No. By the petitioner ଅଛି କି ନାହିଁ?
A decision, not in this letter, but in a decision was taken that both the complaints made against the petitioner and complaint made
on your date charge dele hold karikin dele that by virtue of the order of the FFC was directed to inquire into the allegation made by the petitioner, whether it is factually correct, whether the FFC was directed to inquire into the allegation made by the petitioner. We just want to know it.
No, it is against the petitioner. The FFC was.
Why do you mention that? Come to the next page.
Yes.
136.
Yes, sir.
See the second subparagraph.
Yes. Further, the FFC will also inquire into all such complaints, information, allegations made by Dr. Kanishka Das against any faculty members of the pediatric surgery department, which are on records in addition to existing scope of fact-finding as communicated. So, for this I have made that step.
Yes, all right. So, what is the fact-finding inquiry about this aspect? If they have been asked to inquiry both the sides,
yes.
So, what finding has been arrived at by the FFC relating to the allegation made
by the petition? Yes. That I have taken.
Fact finding report apno place kale 70
that might have done separately. That I have to take it.
For this another
maybe.
Oh.
That I have to take. Oh. It is only for the petitioner.
Oh.
That instruction I have to take.
And 15 ର orderଟା ହଉଛି against the petitioner. 22-5 ରେ ହଉଛି ଗୋଟେ fact finding inquiry.
ଆଉ ଗୋଟେ ଥିବ.
For that I have mentioned. So overall, my respectful submission that let the inquiry be completed. If your lordship wants a target,
we say that he is participating.
Yes, participating.
He is cross-examining the witnesses. He is also producing his own witnesses.
Yes.
He has also filed an application to recall some witnesses.
Yes, ma'am.
2 witnesses,
yes.
as you say.
Management. Yes, ma'am.
That is pending for consideration.
Yes, ma'am.
And it is almost at the fag end.
Yes, ma'am.
So that is why it should not be disturbed.
Yes.
And if any finding goes against him, then he has to the remedy. That is your exact.
Yes, ma'am.
Yes, Mr. Palith, anything you want to say?
Yeah. Mallards. Broadly, Mallards, your lordship has Mallards appreciated both sides of the argument, Mallards.
Yeah.
I have also immediately this first order was served on me on 18 Mallards on 15/5 that order, and immediately Mallards on 18/5 I have raised the objection that your lordship finds at page 80, 85, page 85. At page 86, this is my reply to that letter dated 15/5, that constitution of the committee. Then immediately I give a reply on 18/5. However, moreover, from the tone and tenor and wording of the office order dated 15/5/2020, this is that 135 page, Annexure C2. It appears that the issue has already been prejudged and the committee has been provided with a prepared conclusion. It seems that the FFC is being constituted only to examine my conduct. Exactly what I was saying, I was unable to locate this document in the first hour. In the center, in the entire episode, vis-a-vis the allegation levels against me by some faculty members of the Department of Pediatric Surgery and other departments. While I am open to examination of this aspect, what is telltale is the complete absence of any reference to the flip side of the issue. That is my allegation, observations on some faculty members. This leads me to harbor a reasonable apprehension. Only after that, page 136 was issued, 22. That expansion in the scope was done only after that. And 91.
No, you say that he is not aware whether this fact finding which was asked to be held by the complaint made by you.
Manner.
For that also this page 136 order was there.
That was subsequent to my letter.
Right, you are right. But
subsequent.
We asked him what happened to that.
Manner. And the fact-finding committee inquiry
has made any inquiry on that.
Contrary to the submission of my learned friend for the central government, fact-finding was with the approval of the governing body. No. First, the fact-finding committee was constituted. Post hoc approval was taken from the governing body. That your lordship finds in the show cause notice itself. In the last part of the show cause notice at page, that's that 173. Sorry. 73.
So it is a different committee which was nominated. That so far as to inquire into the allegations which have been made by you.
Yes.
Because Professor Vivekanand Jindal.
Yes.
No, this is the same. There is no other fact-finding committee on record.
That's the one one.
But please come to 136. That we are pointing out to him. 136 of their preliminary counter affidavit. You come to annexure, that is maybe A by 2 or something like that. Page 136. That is dated 22/5/2020. Did you get it?
Just read out. Further, the FFC will also, this refers to the same FFC as in paragraph 135. Page 135. FFC. They are referring to the same. That is your lordship will prove. That will be proved by the letter, the reply given to me.
No, probably Professor Vivekanand has been taken additionally as an additional member of the FFC.
They have clarified here, page 91.
Yes.
They clarified in page 91.
So apart from these three, another has been taken.
That they have done. Page 95, 91, your lordship will see. More age letter reply to that 18.5 reply to in this connection, it is mentioned that the present fact-finding committee is an administrative mechanism to ascertain fact-finding, not an inquiry and so on, so on, so on. So, the scope of the fact-finding committee is also further included. The complaints of Professor Das against other faculty members. So, what fell from your lordship is correct. That the committee was constituted to do all. So, my learned friend's submission for the senior friend's submission for aims, but there may be another committee, another friend. No. It is only this finding and this committee.
The very committee was
same.
Whether they gave any report or not.
There is no other report.
So far as you are concerned, your complaints is concerned.
Well, there is no other report.
There is no other.
This is the only report. They can't improve it in their counter. Now it's too late in the day to say anything in that respect. And if at all, they could have served me a copy. There is no such report because this is the only report that is there.
Yes, all right. What about the intervention application? Anybody is there?
Intervention, Ramesh Bharati wants to intervene. No, my objection is neither the necessary party nor the proper party.
Not
rejected. Earlier it was dismissed also. Such petition was there before this court.
It was
there, but
yes.
He is not raising anything against you. So what is the question of intervention? He is telling that
my only thing is against the management.
Right.
Because there is a paragraph there, I have not gone through the records because starting will allow this in paragraph 11 of the brief.
Where is my
11 of the
writ petition?
Where is my prayer against you?
No, but is it going to affect you?
No.
It's not.
No way. I am trying to save my job from being thrown out of aims.
Pass it over, Mr. Patil.
It's already over. We have to reserve it. So if he wants to tell anything, he is that. But we do not find he has stated anything against your client. So for which any order is to be passed which would affect your client. so that he is to be given an opportunity to be included or impeded, and then other things will follow. He will be given opportunity to file his counter affidavit, etc. If he is not raising anything,
I'm just calling my lord.
No prayer against him.
nothing, prayer is also totally silent.
Totally none. He is neither a necessary party nor not. There are two principles: a necessary party and a proper party. So necessary party is aims because they want to take me out of the job. They are proceeding against the departmental merits. I am against them. And proper party would be the central government because they are relying on the central government rules. The CCS and CCA rules are the central government rules. So if tomorrow morning, sir,
11, 12 and 13, everything is against me, my lord.
No, it's all right. Something has been. We are not touching all those things. He is advancing an argument in a different way, and we have to deal with it. We will not give any finding either you are against him or for at your instance this is instituted or the complaints were at your behalf. No finding against him is to be given because he is not stating anything.
prayer against him.
Prayer, nothing.
Possibly no finding can be given against him also. There is no prayer. Whatever it is, it's against me versus aims.
It is not touching at any point of time anywhere.
No point.
Who is it?
You are closing, Mr. Counsel.
Your Lordship require the assistance of a short.
No, just don't say that opportunity has not been given.
No, my lord, I will call to my senior, my lord, because he is.
We are making it very clear that we will not give anything against your client, anything. And he is also not raising anything against your client. So we are.
We are not making any such.
And there is nothing to supplement.
Written note,
Report, my lord, will file a written submission.
So we are closing it?
Yes.
Wait. Would your Lordship require assistance of a small written note? Can I?
Yes, you can give it.
I need some time.
By Monday, you can give it.
Then next week.
All right.
I have already submitted a written note.
Grateful.
That is your Lordship's record.
All right, Mr. One senior.
Grateful.
Answer for the ends. Mr. Also for the Union of India. Mr. Pali submits that will file a written note of submission by next week when necessary. The hearing is closed, judgment is over. Mahanti, what is your case? Which is your case?
I have got one matter 70 that your Lordship knows. Item number 70, that national trading matter, that mines matter, where shortfall is there, your Lordship asked the Advocate General.
Item number 70.
70.
The meeting was to held.
Advocate General to give an affidavit.
Yes,
no affidavit has been given as yet.
The Advocate General is having a viral feed.
Advocate General?
Viral fever. And I am instructed to mention before my lords to kindly adjourn the matter to after.
Weather can be almost fever.
On the time, I beg to appear virtually, my lords, for the petitioner.
Yes, sir. What do you want?
My lord, may kindly adjourn after puja.
Last order we passed on 14/8 for us.
My lord, we are aware of that order, and we have also brought that order to the notice of the President.
Mr. Sharma is present, and Mr. Mathi is there, and Mr. Padi was supposed to appear for us for opposite party.
Mr. Padi is for the opinion of side.
So the last part of that order,
They were to file a specific affidavit.
In the order dated 1/3/2024, there was an observation that all the parties should sit together and explore the possibility of amicable settlement. London senior advocates appearing for so and so submitted that since the matter is between the petitioner and the state government, and whether the state government would give any such available land to the petitioner or not. The presence of opposite parties number 4 and 5 may not be required. Be that as it may, since the land and additional government advocate is seeking for some time on consensus of all these parties, list this matter this week. That is the order. On the next date, a specific affidavit shall be filed by the state whether any amicable settlement among the parties is possible or not, and whether any vacant land, as proposed earlier, can be given to the petitioner for the purpose of carrying out mining activity. Order is very clear. So,
it has been brought to the notice of the Advocate General, my lord, and I am instructed to inform my lords that it may kindly be taken up after purification, and in the meantime, we'll definitely come back.
Well, if your lordships could be kind enough, I don't want to press it beyond the time. The opposite side was fair enough to say, and I'll admit that, my lord. They said that this is between the petitioner and the state government, because actually, my lord, they are, if I may say so, proper parties, but not necessary parties in that sense.
Right.
The list is, my lord, essentially between the petitioner and the state. Now, if that be so, and this court, my lord, on consensus has relegated the matter to the good office of the Advocate General, my lord, a slight nudge from the Honorable Court would suffice, that depending upon his health condition and, my lord, his availability, he could have a meeting so that the spirit and the text of the last order is carried forward. It may not be, my lord, that it is kept in limbo. And we come to your lordships. After all, there is an order which asks the Advocate General to call the parties.
So what?
So if your lordships could say that
he has no objection for adjournment is concerned. So if you can sit together in between.
That's right. I'm so grateful. I'll be
period, so that it can be taken off a date after this puja holiday on the consensus of all the parties, so that whatever development takes place in that
it can be informed to the court.
So that is to be intimated.
Yes, Manoj, definitely.
Okay. All right. Yes.
If it could come as part of the order, I'll be immensely grateful, because that will help the Advocate General also.
Proposed to hold any meeting, advance intimation is obviously to be given to the.
Let the meeting be between the
Advocate. Earlier we have clarified it.
So it is clarified, and Mr. Sharma is also clear on that.
Mr. Chetan Sharma, Land Senior Advocate, appearing for the petitioner, Mr. Swanshu Samotraso Martin, Samotra Naliki. Ajay, you J. Kotkia, the Land and Additional Government Party, Mr. Mishra Naliki. And Mr. Mishra submits that due to some personal difficulties of the Land and Advocate General, is not able to remain present today, and the matter may be taken up after ensuing puja holidays, so that the development, if any, takes place in the meantime, will be apprised to this court. Mr. Sharma submits that he has no objection to the adjournment, but if since the case was adjourned from time to time to explore the possibility of amicable settlement, if the state government thinks it proper to have a meeting with the petitioner for on the issue of whether it is possible to give any vacant land as proposed earlier to the petitioner for carrying out mining activities. The same can be done in the meantime. Mr. Mishra submits that he would intimate Land Advocate General that if the meeting is proposed to be held in the meantime, advance intimation is to be given to the Land Council for the petitioner, Mr. Sharma, Land Senior Advocate, so that on the next date, the parties shall apprise this court about the development taken place in the meantime. On consensus of all these parties, list this matter on his tell us the date. Mr. Sharma, which would be the convenient date so that Mr. Mahan...
We'll not hold up your lordship's court, but
I am always here.
4th November.
Yes.
4th November.
4th November. It is on 4th November.
And my lord, I may only say that we were here.
Let it be in the supplementary list on 5th November.
8th. No, my lord, then your lordships may have it on the 8th, my lord.
8th.
8th.
Okay.
Very well.
So in the Friday, the problem is that there used to be a break bench.
Friday.
And Friday, this used to, this tide of
Lord,
matters.
we will firstly have to only report to your lordships, not as to which way it is. Supposing it is settled, then we don't have to take the matter forward.
Then let it come on 4th. Let it come on 4th. We can give some time to that matter on that day.
Very
and
well.
see that if any development has taken place or not at all.
Very well.
All right.
Correct.
Put up this
and
matter.
We were there, my lord, physically day before yesterday. We were there.
4th of November, 2024.
Lordship.
So
great.
Another matter is there. I am given to understand that they are also seeking some time.
75.
Item number 75. If it is they are seeking time, I have no objection, but let it come after vacation.
75, who is the other side? You are for the petition.
Both. I am for petitioner and they are for initial.
No, Mr. Mahathi says that let it come after Puja holiday.
Vacation.
All right, this item number 7.
Hardly got a week.
On consensus after Puja holiday. Hello? Mr. Mahathi's presence note down for the
entry model to continue.
Entry model is
yes,
there. Entry model. Okay.
Pardon me, Lordship. Item number 138, Your Lordship. Kindly take it tomorrow, Your Lordship. There is an urgency in this matter, Your Lordship. It is that Group B Court 1 matter, Your Lordship. They have not given salaries for several months, Your Lordship. Kindly take up this matter.
Make a mention in the first
of this, Your Lords.
My lords, I may be pardoned, my lords. I may pardon, my lords. I am on virtual mode, my lords. I am on virtual mode.
Yes.
My lord, item number 57, it was called yesterday. Today I am there, my lords, but it could not reach, my lords. And tomorrow,
yes,
item 57. Yesterday, your lordship called this matter. I was not there.
It will be called tomorrow. It has been passed over.
Yes, my lord. Tomorrow,
it will be called tomorrow. Please remain present in the first hour.
Tomorrow, my father's Shraddha ceremony.
You have difficulty. It can be taken up next week.
Yes, Friday. If it is not for Friday, but next week.
Friday. This particular list is not for Friday.
I'm sorry, my lord.
All right. So 57 on the prayer of the Land Council for the so and so. Put up this matter in the week commencing from 30th September 2020. Deeply.
Well, the tragedy surrounding the disappearance and alleged death of Kumari evokes deep sympathy. The imperative in the administration of justice demands that guilt must be proved beyond a reasonable doubt. The courts must balance the gravity of the allegations with the sanctity of the legal process ensuring that no individual is convicted on the basis of inconclusive or insufficient evidence. In the instant case, the prosecution has failed to establish the necessary link between the appellants and the alleged crime. Medical evidence does not conclusively prove that the remnants were Kumaris, and the witnesses' delayed testimonies lack credibility due to inconsistencies and the significant time lapse. Furthermore, the legal principles surrounding the recovery of the weapon of offense have not been adequately adhered to. In a cornerstone of justice, that no innocent person should suffer the fate of wrongful conviction, especially when doubts lingers over critical aspects of the case. In view of the discussions as above, in our considered view, the prosecution has not been able to prove its case beyond all reasonable doubts, and it is not sufficient to ascribe the guilt on the appellants. Accordingly, the judgment and order of conviction dated 4/9/10 passed by the learned Additional Sessions Judge Jaipur is hereby set aside.
I agree. Yes.
Item number 24 may be taken up Monday, next.
24 is a hearing matter or oral?
My lord, hearing.
Okay.
My lord, item number 29, that case, my lord, I have actually, I have acted as jailer, my lord. Balangir, he is the accused in the Balangir jail, my lord. But his fact is that he's a taking medicine, my lord, for mental retardedness. A report may be called for, my lord.
No. She is in custody. He is in custody.
Yes, my lord.
So why you are not moving any application for bail? We have to finally adjudicate the matter on merit.
Well, submitting, my lord, there is a hearing matter is going on, my lord.
Yes.
And during the hearing, the part has been done, my lord. So that particular appellant suffering from the mental disease, my lord. That's why he wants a call for a report from this jail superintendent regarding the health condition, my lord.
But what will happen at this stage?
Suppose
I understand.
mental problem asila. So can there be a ground for passing any order of that unless it is that legal insanity aspect is proved in accordance with law
Trial court
as per section 84 of the Indian Penal Code. So
Read with 329 CRPC.
You would have moved an application for bail matter is different.
No,
but at this stage, we have to see that whether the conviction of the appellant under the available material on record is sustainable or not. So that is no connection with that. Suppose even if the report comes that the mental health of this man is not at all good at this time, so can there be a ground to set aside the order of conviction?
The husband of the accused, my lord, the informant, he is told that the accused is mental retarded since before.
We were accepting your version. ଆମେ କହୁଛୁ ଯେ ଅପିଲଟା ବର୍ତ୍ତମାନ ବିଚାର କରିବା ପାଇଁ ଆପଣଙ୍କର ସେ ପ୍ଲି ହିଁ ନାହିଁ ଯୋଉ ସେଠି ମେଣ୍ଟାଲ ଇଲନେସ ର କିଛି ପ୍ଲି ନାହିଁ ଟ୍ରାଏଲ ଷ୍ଟେଜରେ ଆପଣ
ଆଇଓ କହିଛନ୍ତି ମୁଁ ସମସ୍ତ ହଜାର ବୁଝିଛି ତା ମୁଣ୍ଡ ଖରାପ ବୋଲିକି
Now, is it a ground before the trial court? If it is a trial before the trial, ground before a trial court.
ଆଇଓ ବି କହିଛନ୍ତି cross examination ଆଇଓ ଆଉ ଇନଫରମାନ୍ସ cross examination କରିବେ
ରେଫରେନ୍ସ ହେଇଥିଲେ ଆମେ ମିଟିଗେଟିଂ ସର୍କମଷ୍ଟାନ୍ସ ପାଇଁ ତାକୁ ମଗେଇଥାନ୍ତେ।
ମିଷ୍ଟର ଦାସ ସେମିତି କିଛି ପ୍ଲି ନେଇଥିଲେ କି? Trial stage re.
313 ରେ ସେ ଗୋଟେ ବୋଧେ ଖାଲି statement ଦେଇଥିଲେ. The accused has stated that as she is saying that she was mentally. She was mentally disturbed.
Next.
Yes.
All right, next.
List item number 3.
May I please, Your Lordship? The bail application, present bail application filed by the appellant number 1, Budhia alias Budhira Murmu. He has been convicted under section 302, 307, 341 and 34 of IPC and sentenced to undergo imprisonment for life and to pay fine 20,000 rupees. He is in custody since 11/12/2011, more than 12 years.
And the custody certificate?
No, direct summon. With
The Federal Council for the appellant number 1, higher religious, submits that the petitioner is in judicial custody since 2011.
Yes, my lord.
2011.
Yes, my lord.
That the Federal Council for the state for the custody. jail. So jail
My lord, Khuntuni jail.
Yes.
14 ନହେଲେ 8 ଥିବ ନା, ଖୁଣ୍ଟିଣି ତ ଜେଲ ନାହିଁ। 8 ଜେଲ
My lord, may be
ସବ ଜେଲ 8
ଆମେ କିଛି ଲେଖୁଛୁ put up this matter 7 ତାରିଖ ରଖିବ ଗୋଟେ ସପ୍ତାହ ଭିତରେ 8 ମେ କହୁଛନ୍ତି 8 ଆମ 7 10 2020 next.
No pleasure.
My lord, petitioner starting from north, the north 26, my lord. I have still not received the certificate copy of the surrender certificate. It does not receive the certificate copy through WhatsApp, my lord. The advocate for the lower court send me through WhatsApp, my lord. The surrender does not.
File that copy. We can ascertain it.
It's a job my signal I got. It was
WhatsApp
get the print out.
Print out what a bar printing day.
surrender copy. Just updating.
ଆମେ ଲେଖୁଛୁ ଯେ ଆପଣ ଫାଇଲ କଲେ
ହଁ କରେ ମୁଁ ମେମୋ ପସନ୍ଦ ଦେବେगा ବାସ ସରେ ମିଳିଗଲା ବାସ ନରେ ସେଣ୍ଡର
the London Council for the appellant submits that after availing the interim bail period the appellant has already surrendered before the London trial court on 10/9/2024 and he filed the surrender certificate which is taken on record. From second line short for the QA that should be read as 21/5/2024. On a series 2-3 letter is now. All right, yes, next.
May I please? The appellant has been convicted, sentenced to undergo RI for life along with fine. देखिए कौन पे the occurrence is of 25/12/2010 and the appellant was inside custody since 31/1/2011. 31/1/2011
ଆଉ ଯାଇନାହାନ୍ତି
ନା ବେଲେ
I will observe same order name 31/1/2011 custody certificate and matter to be listed on 7/10/2020. Here
7 এটা হচ্ছে আপনার
এটা সর্কল জেল বারিপদ।
Yes, next.
Item 6.
Please.
I am sub item 286. I filed one IF for interim bail matter.
Can't find it.
The younger brother of the petitioner leg was amputated my lord, and it said my mother story since more than 10 years. 448.
You have received a copy of the interim application?
Yes, my lord. Last occasion received, and this Honorable directed for.
What is your instruction, Mr.? It will come next week. Why is the time of appointment?
Surgery was done on 29/12/23 and discharge on 12/1/24.
से आइए नंबर तो लिखिए में जो CRLA 286 last down है the application for interim bill and council for the other order passes
Directed to obtain instruction in the matter by the matter. Instruction 8. 286.
Let's fix some further time next week to obtain instruction on the bill application. This matter will be mentioned from 30th of September 2020. Here.
Lordship, same item, sub item number 3, Lordship. Case number CRLA 385 of 2016.
Yes.
Lordship, petitioner applied for interim bail, Lordship. Lordship, his mother in suffering from liver cirrhosis. Lordship.
Our application is pending for extension of interim bill.
Lordship, the coordinate branch granted interim bail, Lordship. Meantime, the period lapses, so we filed the interim application. But after that surrender, we filed the bail application.
Also, the application for extension of the interim bail. One council for the petitioner does not want to place this application.
Lordship.
Also, has not placed. What on file for the interim bill?
Lordship, same ground, Lordship. His mother is liver cirrhosis, one operation is required, Lordship.
Instruction and
Item 385.
CRLA
385 of 2016.
I will make next week.
Lordship, ଏଥିରେ already CDM ଗୋଟେ report ଟା ଦେଇଛନ୍ତି, Lordship ଅଛି.
Instruction short for Dr. listed on the IL number also 3 year period. Not special. Yes, next.
Bill application ID number 1953/2024. The petitioner is filed on last occasion. The Honorable Court directed the Government Council to obtain the custody reports. The petitioner is in arrest since 2000.
Custody certificate. What is the offense here?
302, my lord.
Agu rejected that.
My lord, the bail application is rejected on 26/11/2018, my lord.
For 2018,
my lord. Therefore, I have not filed any bail application, but obtain interim application due to the cancer of his wife. He has been granted interim bail for 8 weeks, thereafter 6 weeks extended. That is on.
Yeah.
Shooting.
7 years, 9 months. এটা তারপরেই আগে No, it cannot be. How do you write it in this way? Uddara PS case number 128 dated 23/10/2024 মানে পরদিন গত 23 তারিখ দিନ ତାନାର ଗୋଟେ କେସ୍ ହେଇଛି ସିଏଟା ଟିକେ ଦେଖିଛି ସିଏଟା ମୁଁ ଦେଖିଲି ମୁଁ ଦେଖିଲି ନା ଉଦଳା PS case number 128 341 320 2024
दस नहीं 10-23 ଆସିନି 23-10-24
ହଁ ସତ ଇଏ ପୁଣି ଇଏ ଡେଟ୍ ହଉଛି 11/9/2024 11/9/2024 23/10/2024 14 ହେଇଥିବ ତ 14 ହେଇଥିବ ସେ ଭୁଲ ଟାଇପ କୋଉଟା
14
ଏ ଯୋଉ 2014 ହେଇଥିବ because he was inside the
23-10-2014
24 ଇଏ କେତେ ଆସିଲା 7 years 9 months total କୋଉ ଲେକ୍ଚର We're going 6 years ଅଛି 6 years ଅଛି but previously he was in Uddala LLC for 10 years ଦିଟା ଦେଇଛି 7 years କେତେ କହୁଛନ୍ତି 9 months 9 କଣ allegation କଣ
Allegation as per the prosecution story, he was the owner of the crusher and the deceased is his erstwhile employee. Thereafter, due to the loss, it has been shifted to Boisinga. And after Boisinga, when the same loss is sustained, thereafter the crusher was leased out to PW2, who is the taken this one Danpat, one Danpat has taken the lease, and the deceased was the mediator and also working under them. Since the payment is not as per their story, since they have not paid, he has repeatedly come to the deceased and requested for the payment. And in the meantime, as per the prosecution story, the
eyewitness is there
they are saying that PW13 is the wife. But this
leg କୁ ମାରିଛନ୍ତି ବୋଲି ସେ ଦେଖିଛି PW13 is the doctor doctor ମାନେ PM doctor so what injury he has noticed acha paragraph number 6 punctured wound ଅଛି Doctor opined that the death can be possible by means of seized knife, which was produced before him, and that effect he has opined. The London Council for the Petition, London Council for the State. The London Council for the State has produced the written instructions received from this Superintendent of Subdivision Baripada, with the effect that the petitioner has remained in custody for 7 years.
9 months.
7 years, 9 months. And also instruction has been received relating to criminal antecedents against the petitioner from IIC Udala Police Station. Land Council submits that the petitioner was earlier granted interim bail by this court as per order dated 2/12/2020 for a period of 8 weeks, which was extended for a period of another 6 weeks, and after availing this and he surrendered at right time. There is no chance of absconding of the petitioner, and there is no likelihood of the appeal being taken up for hearing in the near future, as no paperwork has not been prepared, and therefore the bail application of the petitioner may be favorably considered. After going through the input judgment hearing, the Land Council for this one, so eyewitness account of PW30 and the evidence of the doctor PW14 by not inclining to the petitioner on bail on merit but taking into account the guilty case, 3 months bail granted. Yes.
Right. Now, there is some defect there, my lord. There is a continuation delay. About 18 days delay, my lord. And certified copy is not filed, my lord. I have filed the dispensing certified copy. It's on my lord.
What copy with court
There was the number 112.
Yes.
So
my excuse, my lord. The wrongly I have typically mistake criminal appeal 100, my lord. That will be 110 lordships. That certificate is annexed, my lord.
Who does?
110. Collected appeal is 110 of 2018.
My lord.
No, he has to be 100
Yes.
of 2018.
Yes.
There is a delay has been pointed out
Yes.
by the stamp reporter.
My lord.
That that is to be, what is the delay?
18 days delay.
18 days. 302 case.
Yes, my
lord. I hear number. I will put in the application.
112 to admit.
Yes,
Admit khali.
It's 287 of 18 lordships.
4/12/21 admit. Defects be removed. Delay करना नहीं ना delay करना
Miscase number so-and-so is an application for condemnation and delay. The stamp reporter has pointed out that there is delay of 18 days in filing the criminal appeal. However, it appears from the order number 2 dated so-and-so that the criminal appeal has already been admitted. Therefore, this miscase is disposed of. जो IA file करते हैं dispensing with certified copy. It are connected cases कौन है ना?
Is connected case ना मैंने 110 lordships. 110 of 18. Criminal appeal 110 of 18.
110 is judgment available also no?
Yes, my lord.
Okay.
So far 110 is concerned matter. The lordship has earlier directed whether the appellant is alive or dead. That report has come. Is dead here.
Is dead.
CR letter or plan. So that is mentioned also in the order dated 9/5/2022. So, but in view of that provision, the legal heirs were
yes,
but they have not filed any application. Any application filed? because that period has already expired. 30 days period was there. CRLA number 110 of 2018. As per order dated 9/5/2022, while noting down the submission of the Land and Council for the appellant, that the appellant has expired, the Land Council for the state was asked to obtain the death report of the appellant, and it was further observed that if any legal heirs of the appellant wants to pursue the appeal, they can file appropriate petition before this court within 30 days from the date of death of the appellant. Today, the Land Council for the state has received instruction from Inspector in charge of B Singpur Police Station that the appellant died on date fit ki dena 19/3/2020. Once he came to the brother-in-law 19/3/2020. He died on 19/3/2022. The report is taken on record. No legal heirs of the appellant has filed an application for continuing the appeal. Since the appeal abates accordingly. So it has जो आपण କହିଛନ୍ତି आईएटा फाइल करଛନ୍ତି for dispensing with the certified copy ଆଉ କୋଉ କେସ୍ ରେ ଅଛି ଗୋଟେ ଜଜमेଣ୍ଟ କୁହନ୍ତୁ so that we can dispense with since it is available in courts.
110 minutes. 110 that's it.
110 the dispose of ହେଇଗଲା pending application ଭିତରେ charge the judgment not filed.
So fine.
अच्छा last year अछि 658 of 2018.
सेकंड टाइम फाइल जाएगी
ठीक है देख लो सारी को जजमेंट हो जाएगी और सर्टिफाइड को फाइल कर दो और शेयर करें that is IA number 2238 of 24. Pratham item. There is an application for the dispensing with certified copy of this as well. Land Council for the appellant submits that certified copy of the judgment is available in the connected CRL number
658 update.
658 of 2018, and therefore the filing of the certified copy of this one should be dispensed with since all the appeals are to be heard analogously.
That's 658 and 112 same appeals.
Same appellant.
Yes, sir.
How? Hindi?
Balram Gandhi.
कौन है ना
658 रे दी जण भाई अछन सेम appellant
नहीं appellant आधेरे दी जण let us see CRL प्रथम बार के 100 रे अपन appellant केते जण जणे तापर से आरटारे
3 जण
सरेगा जण से 12 भी होती
तेणु कथि ता पई एटा 658 2018 ने एडवोकेट किए लिखि दियंतु 658 of 2018 since the appellant number 1 Balaram Mondo has already filed CRL number 112 of 2018 which has already been admitted. This appeal is now confined to appellants Utpati Sagaria and Arjuna Gonda alias Polia. Hala? Our acute target konochi CRLS of order number 2 dated smart from the report of the ASR.
Utpati kabi gala mon de Utpati Sagaria.
Honda?
Utpati Sagaria mon de service.
ETV. Sagaria. Aswath Gala. 110.
Last 658
658.
658 ସେ ଅଛି ସେ ଯୋଉ ମରିଗଲା ଗୋଟା ହଁ ଅଛି ଅଛି ଆଚ୍ଛା କଣ ଲେଖିଲା is dead and the appellant number 2 Utpati Sagaria is dead as per the report submitted by the Land Council for the state in the connected CRL number 110 of 2018. अरे ଆଉ ଜଣେ ଫାଇଲ କରିଛି ନା
Arjuna Gonda.
ସବୁ ତ ହେଲା ଆଉ and ଲେଖିନ and appellant Arjuna Gonda alias Kolia has filed CRL number 111 mark. Sahe 11 of 2018 which has already been admitted on 4/12/2011. This appeal is disposed of. Next.
Item 9, political orders, let's see.
one subitem is there, JCRL 71 minor. Power be accepted.
You have filed for power thing.
As there, in the record,
Business petition.
petition and
Intelligence JCRL 71. Okay, just petition regarding engagement of
Rajesh
Minister. Mr. Mishra has filed the Zinama, which is acceptable. Except the name Mr. Mishra, other names shall not be indicated in the constitution.
Okay.